All right. Good afternoon, everyone. I am here today to talk about estate planning. I'm very happy to be here. Um, all right. Like mentioned, my name's Melina Dinwiddie. I'm an associate attorney with Finkel Law Firm. I primarily practice in estate planning, probate and trust administration, and real property law. I'm including my contact information here as well because I feel like I prepared a presentation that it's a lot of information for an hour. So if there's any questions that I can't get to or can't address, please feel free to reach out, and I'm happy to respond and try to answer any questions that anybody might have after the presentation. All right, considering that this is a Fundamentals CLE, I thought it was appropriate to talk about just the basics of will drafting. Wills are, or the last will and testament is the most basic tool that an attorney has when it comes to estate planning, in my opinion. So I thought it was good for today's CLE. And to begin, I'm going to talk about some of the formalities that are required under South Carolina law in order to have a valid will that will be upheld and probated by the court. So the first thing that you have to have in order to create a valid will is testamentary capacity. Under section 622501 of the code, it lays out who can make a will. And pretty much the requirements are very basic. One, you have to be of sound mind. You have to have testamentary capacity. You have to not be a minor, which is part of that capacity to make a will. So addressing the easy question first, what is a minor in South Carolina? And basically a minor is anybody that's under the age of 18 years old. There are some exceptions to this. The first is if you are legally married. So if you're under the age of 18, I think it's required to have parental permission in order to get married. But if you're legally married, you're not considered a minor. And the same if you have been legally emancipated, which would require a court order from the family court finding that you have been emancipated from the guardianship of your parents, that they no longer have any duties or responsibilities for you. So now you're not a minor anymore. So in both of those instances, that would remove you from being a minor and allow for you to have the capacity to make a will in South Carolina. So the harder question is, what does it mean to be of sound mind in order to have that necessary testamentary capacity? In the case that I really like a lot is Weeks v. Drawdy. Mrs. Weeks was an 81-year-old lady, and she, due to her age, her children were concerned about the state of her health and her ability to take care of herself. She had 2 daughters and 1 son, and the son decided to petition the court to have a guardian and or a conservator appointed, and the court had some experts evaluate Miss Weeks, and they determined that due to her health, she was failing in some ways. However, she still had the capacity to know what was going on and to express what she wanted done with her affairs. With that said, though, the court did find it appropriate to appoint a guardian, which was one of her daughters, and to also appoint co-conservators to handle her financial affairs. One was her son, and as a co-conservator, the other was her daughter. To say the least, Mrs. Weeks was not very happy with her son's petition to have the guardian and conservator appointed. So what she ended up doing was, just about a week later, she went to her attorney and she had a will drafted. And in her will, she left her entire estate to her 2 daughters equally, and she left $1 to her son. And during that meeting with her attorney, when she was drafting the will, she was able to express to her attorney who her children are. She knew all 3 of her children. She also knew who her longtime caretaker was. She was able to express what property she owned. And even though she mistakenly believed that she still owned property that she had previously sold years ago, she did understand what property she also currently owned. And she very adamantly explained to her attorney exactly why she was making these dispositions as she was. She expressed her displeasure with her son, and the reasons why she did not want to leave anything to him, as well as the reasons why she didn't want to leave anything to her caretaker. And the reason for that was it was explained to her that there could be a presumption of undue influence if she left her estate to her caretaker. And she, understood that and expressed that to her attorney. So the rule to take out of Weeks and Drawdy that the court expressed is that if you are able to understand your estate, the objects of your affections, and the people to whom you want to leave your property, that is sufficient to show that you have the capacity to execute a valid will. As you can imagine, after she passed away, her son was very upset about only being left $1, and he did challenge this will before the court, and the court did end up holding ultimately that Miss Weeks did have capacity, and they laid out this test that you see on the screen here. The reason why I like the Weeks and Drawdy case so much is that it also gives a very good summary of the case law and the prior decisions of our courts as to mental capacity when it comes to leaving a valid will. Some things to glean out of this case is that the mind is presumed to be sound. It is on the challenger of a will to overcome the presumption that the testator was of sound mind when they left the will. In this case, the son was not able to overcome that presumption. The court disagreed that just because there was an order appointing a legal guardian, a conservator, that she did not have the capacity to make a will. That's not the case. Just because you have these appointments, it has no effect on your testamentary capacity. Additionally, it was noted that the capacity that is necessary to make a will is much less than that of a contract. It was also noted in the Drawdy case that even an insane person can make a will. And they summarized a prior decision of the court where there was a man who was found to be legally insane. He was naked, living in a log, and believed in devils and demons, but he did execute his will during a period where he was found to be sane, and it's perfectly fine to execute a will during some kind of interval where you're of sound mind. So it's not, I guess the point that I'm trying to make is just because there's been a conservator appointed or there's insanity, or the example that I use a lot is just because you've been diagnosed with dementia or Alzheimer's, this does not negate your testamentary capacity. You're still able to make these decisions for yourself as long as you're executing your will during periods where you have sound mind, or if you have lucid period. The other big thing to take out of this is fairness is not required. And this is something that I have to explain to people a lot, just because a testator had 5 kids and he decided to leave everything to one child, that does not negate the validity of the will. There's no requirement that the testator be fair. And this state really upholds the testator's ability to make decisions for themselves and control their estate even after their death. A quote from the Weeks case that I really like is that capacity to know and understand rather than actual knowledge or understanding is sufficient. And this came up because I mentioned earlier, Miss Weeks, she forgot that she had sold some property. So she believed that she owned more property than she actually did. Even though she was incorrect in this knowledge and understanding, she was still able to demonstrate that she had the capacity to know and understand. So there's a difference, and this is an important distinction to make. So from the Weeks case, we can take a couple of good practice tips out of this. With these things in mind, and the way I explain it to my client is you have to know what you have to know who your people are, and you have to know how you're leaving your stuff to your people, basically. So, know your heirs, know your estate, and know how you're leaving things. So what I tell people to do is keep this test in mind. And when you're doing that initial interview with your client, first of all, meet with your client individually. Do not allow anybody else to be in the room necessarily, unless it's one of your paralegals or staff members. If there's a family member that brings your client to your office, I would highly recommend not allowing that family member to be in that initial meeting. You need to be making some kind of judgment on your own if this client has the capacity to make a valid will. So meet with them individually and document your interview. Keep notes on, ask your client questions about what property they own, take notes on that. Ask your client questions about the objects of their affection, meaning who are their loved ones, who are their family members, okay? Make notes on that, and ask your client how they want to distribute things. And a good question to also ask is why? Is there any reason or rationale, especially if your client has decided that they don't want to leave something to a loved one, or especially a child? Make a note in your file about why that is. That way, if there is ever a potential challenge down the road, you're ready to defend that and protect what your client wanted, that this is a valid will and it should be enforced. Some other good tips: after the execution of the will, or even before, have the testator sign an affidavit, or even do an affidavit yourself, hitting these key points that they understood this, and supporting the fact that the testamentary capacity was there. Finally, something else that I'll do is I always have independent witnesses, members of our staff or employees of the firm, to serve as witnesses to the execution. After the execution of the will, if you have any concerns whatsoever, have your witnesses draft up a memo of their own that you can save to the file about their own observations as to the mental capacity of the client at the execution meeting. And then finally, it's always a good idea to mention to your client that if any bequests are being made to somebody that can be considered a fiduciary, there could be a presumption that the bequest or the client was unduly influenced, the testator was unduly influenced to cause them to leave these bequests to the fiduciary. This can come up a lot of times if the bequest is left to a child, for example, and that child is also the power of attorney, or if a bequest is being left to a caretaker, like in the Weeks case, she didn't leave it to her caretaker because she understood that there could be this presumption of undue influence. And this is just something that you should advise your client of. And again, document it, make a note to the file. So the second part of a valid will is not only do you have to have, or does the client have to have, testamentary capacity, you also have to be sure that you meet all of the execution requirements. And these are laid out in our statutory code 622502. The requirements are pretty basic. Again, it's fairly simple to create a valid will in South Carolina. The will has to be in writing. It has to either be signed by the testator themselves, or it has to be signed by somebody else at the testator's direction and in the testator's presence. So we're talking about signature by proxy here, but it has to be in their presence. And then finally, it also has to be signed by two individuals who are witnessing and attesting to the fact that this is the testator, this is their will, and they're signing this will. The witnesses also have to witness either the testator signing the will, or they have to witness the testator's acknowledgement of the signature in the document. So those are the requirements of the witnesses. So what we get here is that holographic and handwritten wills are perfectly fine. The statute only requires that it be in writing. So as long as it's a handwritten document and it meets the other requirements of a signature of the testator and 2 witness signatures, the will should be good to go and upheld by the court. Oral wills are not okay. The state does not recognize an oral will. Also, if the will has been executed in a different state, in order to be valid in this state and upheld by the probate court, it either has to comply with the laws of the state, or it has to comply with the laws of either the place where it was executed, or it has to comply with the laws of the place where the testator was domiciled at the time of their death. So if we're going to probate a Connecticut will, for example, you want to make sure that, it either complies with the laws of our state or it complies with the laws of Connecticut, if that's either where it was executed or where the testator was residing at the time of their death. Importantly, nowhere in the statutory code is it required that a notary public sign the will. For reasons I'm about to discuss, it's highly recommended. However, I would never do a will myself without 2 independent witnesses as well as a notary. All right. So those are the basic requirements of creating a valid will. I'm going to talk a little bit about some additional clauses that I would recommend, as well as just some general practice tips and some concerns that you should be aware of. The first thing is these self-proving and attestation clauses. The purpose of this is so that it expedites proof that the will is valid for the probate process. If you don't have the self-proving and attestation clauses in your will, what the probate court may do is, when it's submitted to be probated with the court might require additional testimony or affidavits of witnesses to prove that the will was indeed valid, it was executed by the testator, it was properly witnessed, and the testator was of sound mind. Now, you can shortcut this by including these clauses in your will, and they're found at 62-2503. And basically what they say is everybody's going to sign all together. The testator is signing, the witnesses are signing, and you're having a notary public sign. And they're declaring that they've witnessed each other sign these documents, that it was duly executed, that the testator had testamentary capacity at the time of execution, and that there was no undue influence, that the testator signed it voluntarily. So this is covered in these clauses, and by using these, having your witnesses sign and your notary public also sign, it's going to make the process a lot easier. And like I said, the code is included at 62-2503. And in fact, it's right there, just copy and paste it. I copy and paste it, and I would absolutely recommend that this be in every single will that you draft moving forward. All right, just a general practice tip, something that you should also advise your clients about is to be wary of interested witnesses. I said that 2 witnesses are required to sign the will. So the question comes up, what if the witness is inheriting under the will, right? That would be considered an interested witness. They're a devisee of the will. Or what if the spouse or the issue of the devisee is the witness? So they could stand to inherit that way via the will through their spouse or issue. So it could create a presumption of undue influence. And in order to avoid that issue, what the court has decided is that If an interested witness is one of those two witnesses that executes the will, anything that they stand to inherit through the will that is above and beyond what they normally would have inherited through intestacy, they're not going to get. That's the excess amount. Anything above or in excess of what they would have received had there been no will and they just inherited under intestacy law, then that excess amount is not going to pass to them via the will, and it would instead pass via what the intestacy code would say. So one way to avoid this is if you are having an interested witness sign as a witness to the will, make sure that you have somebody else to also sign. So what I mean by this is if you have an interested witness who signs the will, and then you have two additional witnesses, so three total, and two of them are non-interested witnesses, then the interested witnesses' bequest or devise under the will is not going to be affected. It's not going to be limited to that intestacy share. Instead, they will receive the full gift. My practice tip is this: just don't use interested witnesses if it can be avoided. I almost always try to have will executions occur at my office. And because of that, I'll always use staff or employees here at the office to serve as witnesses. That way, there's no question that they're an interested witness, and we just take that concern out completely. Additionally, we'll also have somebody else serve as a notary. It's our common practice to use two witnesses and a separate notary. That's not required under South Carolina law. Just as a best practice, though, the more independent people you have in the room to observe the execution, the more witnesses you have to, if needed down the road, to uphold the validity of that will and the will execution in the future. The other practice tip that I would say is to always use that attestation and self-proving clause. Again, it's going to shortcut the process. And I know that this isn't in the statutory code anywhere, but this is just the practice that I always go by. Always use blue ink. In order to probate a will in South Carolina, the court is going to want it to be the original will. And I know that you can make color photocopies, but by using blue ink, it's a lot easier to be able to distinguish the difference between an original document and a photocopy. So just as a general practice tip. All right, the next thing that I wanted to talk about is the memorandum for tangible personal property. This is not a requirement of the will, but if you want to use it, you can use it. And there's a provision for it specifically in the code at 62.2.512. And what the code says is that a separate writing can be attached, or not even necessarily attached, but a separate writing can be used in conjunction with the will in order to dispose of tangible personal property. So it cannot dispose of monetary amounts, it can't dispose of real property, but if it's something like your baseball card collection or a family heirloom or something like that, you can use a memorandum to dispose of that. The will needs to refer to the memorandum or some kind of written statement. It has to be signed by the testator, but it does not have to be signed by the witnesses. So the execution requirements of this memorandum are not the same as the execution requirements of the will. The memorandum can be prepared at any time. You can have a client that might list out what they want done with personal property items and bring that to your office before the will is even drafted. You draft up the will and they execute the will, and as long as the will is referring to that list, handwritten list, and that list is signed by the testator, it's going to be enforceable to dispose of the property listed. You do have to make sure that the property listed is listed in a way that you can reasonably determine or be certain of what the item is and to whom the testator wants it to be left to. What I always do is I always recommend that that memorandum be kept in the same place of the will or as the will, if not directly attached to the will. I mean, why not? Just staple it to the will. That's what I always tell my clients. Or if they don't, they might have something separately, just instruct them to keep it in the same location. So as I mentioned, it doesn't require the same execution requirements. It only applies to tangible personal property. It can't be monetary gifts. It can't be a business interest. Also, it can be completed at any time. It can be replaced. It can be in the testator's handwriting. It can be discarded entirely. So what my practice tip is, and I do this all the time, I always prepare a blank memorandum. I always attach it to my will. And we always discuss it at the execution meeting. And if the client has already, told me ahead of time what they want to be left, or if they decide right there in the execution meeting, we'll go ahead and we'll prepare that memorandum and fill it out, and I'll have the client sign the memorandum. But I know that things change. I might have a beautiful watch that I want to leave to my cousin, but then my cousin does something that really irks me and we're just on bad terms, and I completely change my mind. Instead of having to do a codicil or to redo the will entirely, the benefit of a memorandum is that the testator can simply rip it off, throw it away, and complete a new one. So what I do is I'll prepare the memorandum to be completed at the execution meeting. But what I'll also do is I'll just print like 3 extra copies and explain to my client what the procedure is, and explain to them that this is something that can be done at any point in the future that they decide. All right, the next thing that I want to talk about are the rights of potential heirs that might not have been included in the will. And what I mean by this is, under South Carolina law, if somebody were to pass away without a will, it's considered they passed away intestate. And in order to probate their estate, it would be an intestacy probate, right? And the people that are entitled to inherit through intestacy could be the spouse, if the decedent is survived by a spouse, as well as any children that they might be survived by. That's just the very basic level of the intestacy code. So what would happen if there is a will and these people are left out? So what are their rights? So the first thing is the rights of the surviving spouse. And in this instance, what I'm going to talk about is where the testator was married before the execution of their will. They did not provide for their spouse in the will, and they died at a point where they were still legally married to that spouse. So in South Carolina, it's very important to know this. In order to end a marriage, there has to be a legal order. It has to be legally dissolved. Okay, so just because you're separated and you've been separated for 20 years, just because y'all don't live together, you haven't talked to each other in ages, some other states may recognize a legal separation. South Carolina does not. So let's say you're married and you've done a will, and then you filed for divorce. And this divorce has gone on for 2 years. And in fact, the court has even issued an order of separate support and maintenance, but they have not issued that final decree of divorce. And you die before that happens. You're still married in the eyes of the law legally here in South Carolina. And that surviving spouse could have or does have a right to your estate. So even though they might be in the will, even though they might not be in the will, or even though they're in the will, but the will specifically says, I don't want my wife to get anything, that's ineffective. You can't do that in South Carolina. In order to disinherit a spouse in South Carolina, you have to have some kind of written agreement, such as a pre or a postnuptial agreement, and it has to be signed by the spouse, acknowledging the fact that they're not going to be inheriting and they're waiving that right to inherit. So it's very important to know that if you do pass away and there is a surviving spouse, that spouse would have a right to petition the court for what's called their elective share. So in South Carolina, if you're survived by a spouse and the spouse was not provided for in the will, or even if the spouse was provided for in the will, but it's far less than the elective share amount, which is 1/3 of the probate estate. Let's say you can't get around this by just saying, I'm going to leave my wife $10. And unless you only own $30 in your probate estate, the surviving spouse would have a right to petition the court for their elective share, which would be 1/3 of the probate estate. And when you're calculating the size of the probate estate, what we're talking about is the property that will pass under the will, as well as any property that won't pass under the will for any reason, if it were to pass via intestacy. So it's all of your testate and your intestate property, minus the funeral costs, administration of your estate, and any creditor's claims against the estate. The other thing to know is that you can't hide your property in a revocable living will and say, oh, well, it's not part of my testate or intestate estate, so it's not part of my probate estate. Therefore, my surviving spouse can't get a hold of it. That's not what the courts have decided, and it's not what the legislators have decided either, because it's in the statutory code that a revocable inter vivos trust will be treated as illusory when you are calculating the size of a surviving spouse's elective share. So just because you put it into a revocable living trust, it's still part of your probate estate for this calculation purpose. Another note is that a surviving spouse may only claim this right to the elective share during his or her lifetime. So let's say the testator passes away and the probate is opened, maybe 5 months later, and 2 months after that, the surviving spouse also passes away. The surviving spouse's heirs or personal representative is not going to be able to go back and try to claim an elective share on behalf of that surviving spouse who is now deceased. So what is the process? If there is a surviving spouse and they're going to go after this elective share, how is this going to work? First, they have to file a summons and petition with the probate court, and they have to serve it on the personal representative of the estate. This has to occur within the timelines. I've put them here in this PowerPoint, within the timelines of the statute. So there's a certain period to do this, but the surviving spouse has to file the summons and petition with the court. They have to serve the personal representative, and there also has to be a duly noticed hearing by the probate court. And what that probate court is going to try to determine is, well, first of all, that they are the surviving spouse of the testator, but also determine what is the size of the elective share. So it's going to be a determination of the size of the probate estate entirely. There are some set-offs here. It's going to be set off with the homestead allowance or any other benefits that that the surviving spouse might have received. And then once the size of the elective share is determined, obviously it could affect the other devisees of the will. So if the testator left 100% of all of his estate via that will to, the daughter, and left out the surviving spouse entirely, and then the surviving spouse petitions, that daughter's share is no longer going to be 100% of the estate. It's obviously going to be abated to allow for the elective or the 1/3 elective share to the surviving spouse. All right. The other instance of a surviving spouse, in this case, it's not that the testator was married at the time that he or she executed the will. Rather, they've executed a will and then subsequently got married, but failed to then go back and either add in their new spouse or make some kind of provision for their spouse. And when they pass away, the surviving spouse is the omitted surviving spouse is left with nothing based on the will. So what that person can do, what that surviving spouse can do in this instance, is kind of similar to the elective share. But in this case, what they're going to do is they're going to petition the court. They're going to serve the personal representative. And if the court agrees, this is an omitted surviving spouse, instead of a 1/3 elective share, what the omitted surviving spouse would be entitled to is whatever they would have received via the intestacy code if there had been no will, so their intestate share. Let's say that the surviving spouse and the testator, there were no children of the testator, right? In that instance, the surviving spouse would be entitled to 100% of the probate estate. So it depends on, in the specific circumstances, what the percentage interest would have been had there been no will. If the surviving spouse, if the testator was survived by the omitted surviving spouse and one child, then the elective share in that instance would be 50% that the omitted surviving spouse could be entitled to. Some exceptions to this rule would be if it's evident from the will that the omission was intentional. Also, if there's evidence to show that there was a transfer in lieu of a testamentary provision. In other words, the testator made some kind of transfer prior to their death in order to provide for this omitted surviving spouse. So what about the kids? Unfortunately, there aren't that many rights for the kids. If there's a will and they're left out of that will, again, going all the way back to one of my very first slides, wills don't have to be fair. So unfortunately, if a child is left out of the will or written out of the will, very likely they're not going to have any rights to try to get an interest in that estate. The only time that a children does have rights to inherit from the parent's estate is if the parent died without a will. They can inherit via the intestacy code. Or if the child is considered a pretermitted child. And what that means is a child that was either adopted or born after the execution of the will. And in that case, Section 62.2.302 addresses the rights of a pretermitted child. And it's very similar to that of a surviving spouse. Again, there's going to have to be a summons, a petition, service on the PR. But what they could stand to receive is a share in the estate that is equal in value to that they would have received had the testator died intestate. So again, the idea here is that they want to basically get what they would have gotten under the intestacy code. And similar to an omitted surviving spouse, the court will, allow for the pretermitted child share to be granted unless there's evidence that the omission was intentional. Thinking back to the Weeks case, for example, she left in there that she was only leaving $1 to her son. Part of this was also to show that this was intentional. She didn't just forget about the son. In that instance, the son was not a pretermitted child. However, the idea or the concept here is the same. By leaving that $1 devise, she's basically saying, I didn't forget about you. This is intentional. I'm not leaving you anything. Again, similar with the omitted surviving spouse, if there's evidence that there was a transfer in lieu of a testamentary provision to provide for that pretermitted child, that would suffice. And then the other exception to this is that if all of the devises in the will are substantially to the spouse, so if the husband passes away and he left 100% to his spouse, a pretermitted child is not going to be able to then challenge that, petition for their elective share, because the concept here is that in theory, when the husband left everything to his surviving spouse, that surviving spouse is believed to use that inheritance or use those estate assets to also care for that child, that pretermitted child that was left out of the will. All right, some practice tips here for you guys. Whenever there is any kind of major life event that your client experiences, especially when it affects the family unit, encourage your client to call you to review the will and to consider, does anything need to be changed here? Once you get divorced or remarried, or if there's a death of immediate family member, new children like we just talked about, it's time to update the will in most instances. So encourage the client to review their will after any major life event. And just as a good general rule of thumb, encourage your clients to review their will every year or so. It's always a good idea. Just make sure that nothing has changed significantly to change how you want your estate to be left. The other practice tip is CYA letters. Cover your booty here. Anytime that you think there might be an issue, write it out, make a memo, and make it known to the client. To give you guys an example, I did a will for a client not too long ago, and he was estranged from his wife, and they had been separated for 30 years. She lived in another state at this point. He didn't even know where she was or how to get in contact with her. So I felt that it was very, very important, one, to verbally explain to my client, she could come back and assert her elective share and seek a third of your estate. So you need to be aware of this. What I would recommend is that you do everything that you can to get a divorce or get your divorce finalized as soon as possible, or else these are the repercussions that could happen if you pass away and you're still married. So I, of course, did a CYA letter, and I put all of this in writing, including the applicable statutory code as to elective shares. I provided it to my client. I also made my client sign a copy acknowledging that he understood, and I kept that in the file. So CYA letters are always a good idea if you ever think that there's an issue. Just as a little aside, my client, unfortunately, he did pass away and he was not able to get that divorce finalized. We are working towards closing the estate now. And so far, fingers crossed, the spouse hasn't popped up, even though she's been properly notified of everything. But she could, and that's something to be aware of and to inform your clients of and make sure that they understand that. Another thing is if a potential heir is purposefully being disinherited, such as Miss Weeks disinheriting her son or leaving him $1, you can, this isn't required, but you can make the intent clear in the will. You can make it known. It doesn't have to be specific, but it can be something very basic, as, I'm not leaving anything to my daughter Susie because we've been on less than amicable terms, and we no longer have a meaningful relationship. Just anything. Just put it in there so that it's known. Again, I didn't forget about this person. This is why I'm not doing this. And again, this goes back to after the execution meeting. If you have anything at all that makes you think this could be challenged for any reason, have the testator do an affidavit and sign it before a notary, and keep it in the file so that you have some kind of evidence of what the testator's intent was and what their rationale was at the time of executing that will. All right, I just have some final thoughts and considerations for you guys and tips that I think that are important and useful. The first is having to do with no contest clauses. This is something that I do use frequently in most of my wills. It just tries to help avoid any issues down the road. It can prevent any unnecessary litigation and expense. And basically what the no contest clause is going to say is that if anybody contests this will and they lose, unsuccessfully contest the will, they stand to also lose any devises that were left to them in the will. So let's say, for example, we leave our son $10 because we don't like our son, but we leave all of our other kids lots and lots of money. And then the son comes around and contests this, okay? If he is unsuccessful and he does not show that there was any undue influence or that the will was invalid for any reason, then he loses his 10 bucks. Basically. So it could deter somebody from challenging a will. Something to note, though, is that if there's probable cause, okay, if that son really had a reason to think that there was an issue, and he shows that court that there was probable cause to bring this contest action, even if the son loses, that no contest clause will not be triggered, and it's not enforceable. So he'll get his $10. I guess $10 wasn't a good example, but the concept here is that if there's probable cause, the no contest clause will not be triggered, even if the contester loses. Another good practice tip that I like to use is I always try to make the powers for my personal representative as expansive as possible in the will. And the idea here is that we're trying to avoid any unnecessary administration expenses or legal fees by needing to involve the court in things. We're trying to make it easy for the personal representative to probate this estate so that they don't have to keep going to the court to get permission to do things. So just, I mean, very easily, I'll put in my will that there should be no bond required. And a caveat here is that I also only recommend to my clients to choose somebody to serve as their personal representative that they have the utmost trust in, okay? You don't want to obviously name somebody as your PR that might be a little shady and you don't trust them that much because you don't want them to like abscond with all of your money when you pass away. So I always tell my clients to pick somebody that they trust wholeheartedly. And if that is the case, if they have people that they trust, you know, with handling their estate, then I would recommend just go ahead and put in the will that the bond is waived and no bond is required, or else the PR may be required to post a bond in order to probate. And again, we're trying to make this easy for the PR. The second thing is that I always put in my wills that the PR has the right to sell real property without an order of the court, or sell personal property beyond $10,000 without an order of the court. If you don't include provisions like this, the statutory code requires that in order for a personal representative to sell real property or personal property in excess of $10,000, the PR has to get permission from the court. You're going to have to petition the court. You may even have to notify anybody else that might have a claim in the estate. Those people will have an opportunity to request a hearing before the court, before the probate court will issue an order allowing for the sale of this property. So it's just a lot of unnecessary rigmarole, where the point is to allow your personal representative to handle your affairs for you. So I include in my wills the power for the personal representative to sell these items without the necessity of court approval or order. And then the other thing about powers of attorney is, if your client has several people that they do trust, list successor PRs. Don't just list one person and call it a day, because you never know what's going to happen. That person might predecease the testator. That person might not be capable of even serving as the personal representative when the time comes. So it's always good to list at least one successor PR, if not multiple, because you want to be aware that if you don't list successor PRs and the one that you named is not available to serve in that capacity, then who's next? Well, we're going to turn to the statutory code, and there's the whole priority of appointment, and the next person in line could be somebody that your client does not want to probate their estate. So the whole idea behind a will and estate planning in general is allowing a person to be able to control their affairs after their death. And that includes choosing how things go and who handles that for you. So it's important to list successor PRs, in my opinion. The second thing, or another thing to note, is to put in the will, if possible, how you want expenses of the estate handled and what you're going to consider an expense of the estate. For example, this is something that I see a lot, is that the home that was owned by the testator has a mortgage on it. And then the question comes up, well, is the mortgage an expense of the estate? And to just point out a possible, or to illustrate a possible outcome here, is the testator might have left 100% interest in that real property to one person, with the residue being split between other people, right? So if you were paying that mortgage out of the estate, which would fall to the residue beneficiaries, you're essentially paying for somebody else's home, and you're diminishing what the residuary beneficiaries stand to inherit. So it could be problematic if you allow for certain expenses to be paid out of the estate. The general rule in the statutory code says that any property that is subject to an encumbrance, such as a lien or a mortgage, will pass subject to that encumbrance. So it's not necessarily an expense of the estate that should be paid out of the estate. And something to consider when you're sitting down in this initial interview with your client is to discuss with them, what are your assets, or any of these assets encumbered by liens? And if so, how do you want those to be handled after your death? You can write around the statute, but again, the default rule is that it will pass subject to that lien or that mortgage, unless the will says otherwise. So that's a discussion to have with your client. Another thing to talk about is the anti-lapse statute. In South Carolina, we do have an anti-lapse statute. I failed to include the statutory code here. I apologize for that. But basically what the anti-lapse statute says is that if there is a devise left to a great-grandparent or a lineal descendant of that great-grandparent, your great-grandparent, your grandparent, your parents, issues of these people, if it's basically a family member like that, and that family member predeceases you, they pass, The anti-lapse statute says that that device will not lapse to the residuary. Instead, it will go to the issue of that predeceased beneficiary. So, for example, if I leave something to my maternal grandmother and my grandmother passes away and she does not inherit, then that bequest will not lapse. It'll go to my mom instead. So this is the anti-lapse statute will stop that. Now, be aware though, this only applies to these family members. If you leave it to your buddy Bob and Bob predeceases you, what's going to happen in that instance is the device does lapse to your residuary. Bob's kids are not going to get that bequest or that gift. Instead, it's going to fall to your residuary and be split up pursuant to whatever your residue says. So one way to avoid the anti-lapse statute or the anti-lapse is to use this anti-lapse language, making your intent clear that you don't want the anti-lapse statute to apply. The statutory language says that words such as "if he or she shall survive me" is sufficient. So again, the anti-lapse statute, if it's a family member, great-grandparent, or lineal descendant, it would not lapse. However, if you use this language, "if my maternal grandmother shall survive me," that is going to take it out of the anti-lapse statute. And if my grandmother does not survive me, then that gift would lapse to the residuary. Best practice is to just use the language. And if you don't want it to go to the lineal descendant, be sure that you use some kind of language that says, "to my great-grandmother, if she shall survive me, but if she doesn't survive me, then to so-and-so." And then the final point that I had for you guys is the simultaneous death statute. Basically, what this says is that in order to inherit via a testator's will, the devisee has to survive the testator by 120 hours. The purpose of this is so that it basically doesn't go from one estate to the next, that it will have an opportunity to pass to the intended recipient. And yeah, that's it. All right, guys, that's it for my presentation. If there's any questions, comments, or concerns, I know that I am right on the money here as far as time goes. So please feel free to reach out via email or give me a call. Otherwise, I've enjoyed talking with you guys, and I hope that everybody got something out of this. Thank you very much.
Yeah, so we'll just wait a second and see if anybody types any questions, and if not, we'll move on.
Sure.
Well, I don't see any, so thank you very much.
All right, thank you. Everybody have a good day.
Julie, are you there?
Yeah, can you hear me okay?
Are you ready to go?
Yeah, can you see my the cover page of my PowerPoint?
No, it's showing a black screen. It's like your video is off.
Oh. Let me see.
Well, we got video, but we lost your mic.
Okay, can you see me now?
Yeah, we're good to go.
All right. Hello, everyone. My name is Julie Moore. I am a litigator, and I work over at Duffy & Young. We're trial lawyers over here. I really appreciated the invitation to be with everybody today. I feel like I haven't gotten to see any of you in so long due to the circumstances of this year. So I'll take what I can get. And so I'm really happy to be with everybody by Zoom today. I hope everyone is doing well. I feel like that's sort of a hard question to answer when asked these days. Like, you need to qualify it. Like, I think I'm good, but it's 2020, so who can really be sure? I'm sure, like we all have been trying to really focus on, counting my blessings and the things that have been good about the year. And as it relates to my practice and my professional life, things have either paused or slowed down a lot over the past 6 months plus. And it's really given me time to go back and think about what I've been doing in my cases. I primarily do personal injury cases, wrongful death, medical malpractice cases, and some products work. But what is it that I've been able to do to really add value to those cases? And I've had the time during COVID to really think about that and evaluate how I've been able to add value and how I can, double down on those efforts to add even more value to my cases. And so one thing that has just sort of had been percolating and resurfaced is experts, and how when you find a good one and you use an expert the right way and the way they're intended to be used, they absolutely add tremendous value to your cases. And so I thought I would share some of my thoughts with you and how I worked through my approach to experts in today's CLE. So that is my intention. As we know, experts can be very expensive, by far the biggest cost in most of your cases where you're using them, but they're also critical. So I hope that, I'll say something in today's CLE that will spark you to at least examine the way you're using experts in your own litigation matters, and think about whether you can improve upon it, or that you're happy with the way you've been approaching it, because they are so critical to litigation matters. All right, so now I'm going to attempt to share my screen and start the PowerPoint. Okay. Can you guys see the cover page of a PowerPoint presentation?
Yes, we can.
Okay, great. Right, Julie Moore, Duffy & Young. I'm here to chat with you guys about experts. So I think really the first thing to consider is why you want an expert in the first place, right? And I think you can evaluate that, or I evaluate that at 3 different phases of a litigation matter. The first would be pre-suit, and that's really to help you understand the wrongful conduct that you in the case, the wrongful actors and the wrongful conduct. What is it that happened here that would give rise to a claim that I can take into court and file a suit about? So experts can absolutely help you identify and understand theories of liability. I'm going to talk about this more later, but one thing I've sort of leaned into as I've gotten older and more experienced in litigation is I don't have to. It's okay that I'm not a cardiologist, or I'm not a mechanical engineer, and I don't have to try to pretend to be that, because experts exist. So I can do my best to understand a pile of medical records, but I can really bring in the appropriate specialists to help me work through those records and identify what happened with a particular patient, or what happened in a particular tire blowout case that should not have happened. And I can't always determine that on my own. And most of the time I can't determine that on my own, even after doing this for a decade. So absolutely, experts can be and should be used to help you identify and understand what theories of liability might exist. So that means you get them involved prior to filing suit. Ideally, when you're reviewing a case and you first signed it up, I think is an appropriate time to engage with an expert witness. In addition to identifying theories of liability, they can help you evaluate the strength of that liability. For example, I've had often in medical malpractice cases I'm reviewing, I will speak with a consulting expert, and she will tell me, I see a breach there, but here are the problems I see with it. And so in a lot of those instances, I've decided not to take that case for that reason. And so I think that experts can be tremendously valuable in helping you not only understand the liability you want to pursue, but also understand cases that you don't want to take because either the liability is shaky or or the damages aren't there to make the time and expense and the investment by your client worth it. So oftentimes we rely on experts in the pre-suit phase of litigation. And then there are certain instances, medical malpractice, for example, that you can't file, you can't get into the courthouse without an expert. So, pre-suit involvement of an expert can satisfy your statutory requirements to commence an action. And so, that I don't take for granted, and I rely on pre-suit engagement experts more and more the longer I've been practicing because it costs money, right? You can't get an expert to review a stack of medical records or review the particulars or go to the scene of a tire blowout case without paying them. And so there's an outlay of money up front before you even know that you've got a case. But I think that it's worth it, and it's something that I've come to accept as part of a plaintiff's practice. Is you've got to be willing to invest the time and money on the front end to help you identify which cases are worth more time and money and which cases aren't. And so I think experts can be a tremendously valuable tool for that purpose. Discovery. So after you get your expert on board, ideally you've engaged them prior to filing a suit, but now you're in the litigation and discovery has started. Well, I think we're going to talk about this more in a minute, but experts can be incredibly helpful at this phase of litigation because they can help you interpret documents that are produced, testing data from a manufacturing facility, medical records, a myriad of different kinds of information we receive throughout the course of discovery. You may understand it, and especially if you do a lot of the same kind of work over and over again, you have a really good working knowledge of a particular area. But an expert might see something that you missed, or they might notice the absence of something that you didn't know to look for. So I think it's very helpful to get your experts involved with reviewing and interpreting documents that are produced in discovery. Experts can also help you craft written discovery. That's something that I've done a lot more in recent years. Ask the expert, like, what information do you need, or what would be the ideal testimony or responses to interrogatory I could get that would support the way you're viewing this case. It would help you confirm this issue that's outstanding in your review of the case. Ask your expert that, and if it's a good expert, they're going to be more than willing to help you do that, to help you craft effective written discovery. Absolutely help you prepare for depositions. The deposition of the opposing party, I really have in mind like the defendant in a personal injury case, that defendant doctor, speak with the companion expert that's in the same specialty and really work to prepare for that deposition to get that ideal testimony that the expert wants you to try to get, or that would be helpful to their review of the case. But you've got to get the expert on board to tell you and help you prepare for that deposition. And then absolutely, the expert is huge at trial, and that's when they come on board to help you educate the jury. They lend credibility to your theories of liability. I mean, it's a professional witness that comes in and takes a stand in support of you and your case. It's incredibly powerful, just in the presence of it, and especially if you get the right expert in helping to actually educate the jury, so that when you stand up in your closing argument, you can build off of the credibility that the expert witness has helped you establish with the jury and really hit those points home in your closing argument. They can also help you develop for trial and present demonstratives. So, diagrams of the spine, or a diagram of a tire, or, whatever it is that might help illuminate for the jury what the issues are in your case. The expert can help you, create that and figure out how to best use it and explain it to the jury. And that may, the expert may be the only witness that you can appropriately do that with. So that's not something to take for granted. So I think those are the three reasons that you want an expert. But really, the overarching reason, the reason why you want an expert and why you're going to invest all of this time to do these things I just mentioned is because you want the expert to add value to your case. Otherwise, it's not going to be worth it. Okay, so now I want to talk to you guys about evaluating potential experts. Okay, because I think that this is something, as I've grown in my practice, I spent a lot more time doing than I might have when I first got started, and I think it's paid off. I feel like every hour I spend looking for and evaluating potential experts, it is worth it, absolutely worth it. But it can be a task, absolutely. But you've got to just lean into it and know that it's going to be worth it when you find the precise expert you need with the perfect presentation style, or whatever it is you're really going for in your case. Spending the time to find the right one is not something that I think any trial lawyer is ever going to regret. One sort of practice tip that I would offer is not to outsource the looking for, the search for the right expert to a paralegal or a young attorney new associate. I think that if you're going to be the first chair on the case, it's absolutely worth it for you to take the time to not necessarily find all of the candidates that you might want to consider, but to speak with them before you retain them and bring them on board. You be the one to do that. If you're going to be the one that is, defending their deposition, you're going to be the one calling on them to help you prepare for other depositions. You're going to be, directing their examination at trial. You want to make sure that you like what you see and you like the package that the expert's going to bring to the table. So just as a practice tip, I've gotten away from having anybody other than me be the one to make the final decision and the evaluation, typically over the phone, of the expert candidate before I bring them on board and retain them.
Julie?
Yes.
So we can only still see this first page. The PowerPoint hasn't started. I don't know if you meant for it to.
Oh, okay. Because it looks like it's going forward on my, let's see.
We just still see the first.
Thank you for pointing that out. Let me figure out how to. Can you see it now?
Yeah, we're still on experts adding value to your cases.
Okay.
If you just want to try to maybe click these slides on the left as you go through them, or just go to the full start slideshow.
Okay, so you're seeing, oh, okay.
No.
So now you can see the second slide, or
Yes,
you can see,
yeah.
okay. Yeah, because when I open it up to play the slideshow, I can't get it to share that particular screen. Okay, sorry guys. Not that there's any magic to the first slide that I showed you, but I just sort of outlined the three major areas of a litigation claim that you'd want to consider using an expert, and that's pre-suit, during discovery, and then at trial. And then now I'm talking about how to evaluate potential experts. So after you've made the decision about the approach to finding them, I think it's really important to make sure you are determining, and this can take place as you're talking to these potential experts, determine the right fit. And we're going to talk a little bit more about that, and because it's not always immediately clear, particularly when you're trying to bring someone on board prior to filing suit. You haven't gotten to engage in a lot of discovery, but spending the energy to determine the right fit is critical for a lot of reasons that we'll talk about. And we'll also talk about how to evaluate the candidate's backgrounds and make sure that the person that you're going to bring on board is actually going to help you and not potentially hurt your case based on something in his or her background. All right, so there's several ways to go about finding an expert. I use all of them, not always in a single search to find an expert. But these are definitely all ways that I use on a regular basis to try to identify the best candidate for my case. The first one is expert services. You can Google, expert services or legal expert finders, and you'll have tons and tons of private companies pop up that are solely in business to basically be a matchmaker. You pay them a finder's fee and they give you an expert. And this sometimes it can be a very beneficial service. So don't be dismissive of those services. Just take your time to investigate the particular company that you're going to use and the structure of the deal, like how that company is getting paid. And what that payment gets you, whether it's just matching you with an expert or whether that gets you some sort of initial review with a candidate or candidates that they identify for you. Make sure you have a clear understanding of that before you get too far into the process. And also, if you're going to use an expert service, be very, very clear about things that you want in your candidates and things that you don't want in your candidates. For example, this happened to me recently. I was looking for a medical specialist, an infectious disease expert, and I'd been having trouble finding one. So I went to this expert service that I'd used before, and they're typically very good. But in that conversation with the consultant there, she didn't note, maybe I forgot to tell her that I only wanted to talk to expert candidates who had testified in depositions before. I did not want to work with somebody who was a new expert, just because, for a lot of reasons, I didn't want it for that case. And so, whether I failed to make that clear, whether she failed to note it when she got started with her search, I was presented with a candidate that had never testified in a deposition before, and that just did not suit the needs of that particular case. So my practice tip is, if you're going to use these expert services, really think about what you want and what you don't want, what your requirements for that expert are going to be. Geography, cost, if they're coming from an academic setting, if you want them to have clinical experience, if you want them to testify at a jury trial, all of those different factors, and we can talk about that more in a minute. Be clear about those with an expert service, because you're going to end up paying them, a substantial amount of money to help connect you with this person. Make sure that person they connect you with has the prerequisites that you want. I also always, and most of the reputable companies that are in this business work this way, but make sure that you have an opportunity to evaluate the candidate before you have to either submit payment or they'll return the payment to you if you're not happy with the candidate they presented. That's just another practice tip for you if you're going to use these expert services. But the good thing about them is, as we talk about these other methods of finding experts, the difference between using an expert service and using these other means to find an expert is that it can be very quick and it can be efficient. It can be an efficient way to get an expert on board to advance your case. So don't rule an expert service out if you're time crunch. If you get a case like right before the statute of limitations, or there's some reason you need to get somebody on board quickly, an expert service that's an ideal time to use an expert service, because it can fast track getting a candidate in front of you for you to consider. Next, ask the listserv. If you're on listservs, and most of us are on listservs related to our practice areas, or you're involved in legal organizations, ask around for ideas about specific experts, and you'll definitely get tons of ideas. A lot of legal organizations, if they're large enough, will also have a database of experts that you can search, by subject area, by geography. A lot of different criteria you can use to search and come up with a list of experts that may be suitable for your case. But typically, if you just ask a listserv, lawyers love to, in my experience, lawyers love to be helpful and they love to be in the know. And so if somebody used a great neuropsychologist and you ask about one the next day, they're so happy to share a good candidate with you. So I think that's a great resource for identifying potential experts. Lexis and Westlaw both have great tools, not only to help you find experts, but also to research candidates and see what's out there on their background. Sometimes you can almost always find a CV. If an expert has appeared in a case, you can find out, if their testimony has been, or they've been limited in any way in offering testimony at trial, any verdicts associated with cases that they've been involved with, where they've testified. And one of the search engines, I can't remember if it's Lexis or Westlaw, will also tell you like how often a particular expert testifies more for a plaintiff or more for a defendant, which can also be very useful information. And so those are good places to look for candidates as well. Google. So this is definitely the most tedious tool for finding experts, but it really can work if you're willing to put the time in, which you should be, because you're going to spend thousands and thousands of dollars oftentimes on an expert. You want to find the right one. And so I've, when I've struck out with other, because I need some sort of obscure specialty, and I've struck out with other tools, I've just gone to Google. I recently needed a dermatopathologist, right? So it's a pathologist specializing in the skin. And I wasn't having any luck finding anybody through all these other tools I'd use. And so I just started Googling, and I spent a lot of time doing that, just Googling and doing deep dives on like page 2, 3, 4 of my search results. And I eventually found a fantastic expert. He was the head of the dermatopathology department at Harvard University's teaching hospital. Okay, so I mean, and he turned out to be just an amazing, had this amazing way of explaining difficult concepts. He was just wonderful, but he was not, and he'd done some legal work before, but it had been a while. So he wasn't fresh on anybody's mind on the listservs or when I reached out to colleagues. He wasn't a member of any of these, expert service companies groups. He was just sort of out there, waiting to be found. And I found him, and it was worth all the time I spent, because he just added so much value to that particular case. He was fantastic. Another way to find an expert is to ask your colleagues. This is similar to listservs and legal organizations, but just to ask around. Pay attention to jury verdicts in South Carolina Lawyer or wherever you get your sort of South Carolina legal news. And when you find, a verdict in a medical malpractice case, and it was a radiology case, look who that radiologist was and reach out to the plaintiff's lawyer, the defense lawyer, whoever it is, and ask about that witness. I mean, that's also a great way to, stay connected with colleagues, stay connected with people that are doing similar work as you, but also to identify some really good experts who have been, tested and offered testimony at trial that's been effective one way or the other. So that's a really good tool as well. Again, just depends on you sort of mining available information to come up with good candidates, but it's just such a critical task, I think, in litigation. And so my last idea about how to find an expert is one that I think is unique, but can be so valuable if you can create it. If you have, close friends or lawyers that you've worked on a lot of cases on, opposing counsels, just sort of create a small, maybe a circle of trust or just this small group where you can openly discuss cases that you're working on, not ongoing cases with each other, but, if you've got a really good friend who is, a defense lawyer, and he can throw ideas around with you and you can throw ideas around with him. Sometimes it works really well to ask opposing counsel in that practice area. I mean, you want to be careful not to create a conflict so that your friend who's been generous with you is unable to defend the case you're going to bring. But with those sort of constraints, ask opposing counsel, say, hey, I'm looking at this failure to diagnose case. Have you been, who is the best radiologist you've seen testify in a medical malpractice case? And if it's the right setting, I've definitely gotten some really good candidates, expert candidates, from asking opposing counsel about who they've used or who they've seen and thought was very effective. So that's another really good way, I think, to find an expert witness. Right, so I think, also key to the inquiry of finding the right expert is you got to find the right fit. And I mean a lot of different things when I use the terms right fit. You have to determine what kind of expert you need. And, that I think sometimes that's an easy question to skip over. You think, oh, I just need a liability expert, or I just need a damages expert. I think that it's important to slow down and be very careful in how you think about what kind of expert you need. If it's liability, is it you need somebody to offer, testimony as to breach and causation, or both, or or if it's damages, are they going to give you causation and then damages? You've really got to be an architect, I think, about how you put your case together in general, but certainly as to how you're going to find the right fit for experts. And I think maybe a better way to illustrate what I mean by that is to say, like, if you've got a case where you are suing a cardiologist, it's a cardiology defendant, then you want to match that expert specialty, I think, tit for tat. You want your expert to be a cardiologist. And even more specifically than that, if you've got a spinal injury case, well, who performed the surgery that went awry? Was it an orthopedic surgeon, or was it a neurosurgeon? And determine, which specialty that was, and that's who you want your expert to be. You want the fit to be tight. You want it to match, like tit for tat, I think, is the best way to build your case. To get, because it doesn't eliminate, obviously, challenges to exclude or limit your expert's testimony, but it makes it much harder to get your expert's work or testimony limited or excluded. And that's the last thing you want. And everybody knows that litigates. You don't want to go through all of the energy that I've just been talking about to find the right person, get them on board. They go all through discovery with you. They're sending you, bills. You've invested a lot of time and money in this particular expert, only to have them, excluded because their expertise isn't a fit for the case. So that's something you really should slow down and think about, and don't take it for granted. I think the prime example of that is the 2010 products case, Watson v. Ford, where an $18 million verdict was reversed, primarily because it was a misfit on the expert's background and what testimony was offered at trial. You don't want to lose that $18 million verdict once you get it. So make sure you're matching the expert with what you actually need. And like I said at the beginning, sometimes you don't know when you get started on a case, which is why consulting experts or working with somebody at the outset can be very helpful to help you figure out what you actually need. Which brings me to, so sort of my next point when you're considering fit, is you don't want to strain to make the expert fit the expertise you're looking for. So you're going to think about the role that you want the expert to play. Consulting experts can be incredible members of your team. You don't have to, in most cases, you don't ever have to disclose that they're working with you, because you're not going to ever offer them to testify at trial. They're just helping you put your case together behind the scenes. They're helping to educate you. They're helping, to help you figure out what kind of case this is. We work with an MD here, and he is a neurosurgeon. But when I have a medical malpractice case and I can't quite figure out, I'm pretty sure something went wrong with a patient, but I can't figure out what kind of case it is, he will review the records and talk me through where he sees it. Or he's like, I think you might want to talk to a radiologist. You might want to talk to another neurosurgeon. You might want to talk to some other specialty. The consulting expert can help you identify what kind of expert you need to be that right fit. Like I said earlier, it can help you identify whether you have a case at all that would be worth pursuing. So don't discount that role. That can be an incredibly powerful role that you can have an expert play behind the scenes. And then the other, of course, would be the testifying expert. I think a sort of practical way to think about finding the right fit for your expert witnesses is to map out all of the proof you think you're going to need to win your case, like on every single element of every single claim. map that out early, and then plug in who can offer that proof. And then challenge yourself, is that person going to be able to offer that proof? Can that doctor give me causation, or can I get that from the treating doctor? I don't need to retain a separate expert. Or, there's a lot of, it really depends on the facts of your case, but take the time to map it all out, what you need to prove to prevail, and then figure out where you need expert testimony and who you need that expert testimony to come from. I think spending the time to do that on the front end will, as you're sort of mining the world out there to find the right expert, will be very beneficial to you as you start putting your case together, and before you bring an expert on board and start to pay them to work on the case with you. Let's see. Okay, yeah, I just included Rule 702 from the South Carolina Rules of Evidence, which is really this comes from the Watson case I mentioned. That it's the rule to help you determine the qualifications of the expert, and that's really where my sort of approach to practicing of making the expert match exactly the expertise of the defendant or the manufacturing company. You want to get as close as you can, if not exactly to a match of, whose conduct are you challenging, and make sure the person challenging that, sitting in the chair as the expert, matches the wrong actor. In the Watson cases, it's always good to review when you're considering those issues, and it stemming from Rule 702. All right, so you have gone out and used all the tools we talked about to find a list of candidates to serve as your expert. You really thought about the right fit, and you feel like you know what you need, and how your proof is all going to link together to get you that big verdict, either defending against one or getting one for yourself at trial. How do you evaluate this list of folks in front of you to figure out who you should retain for your case? Credibility, and I think really all of these other ways to evaluate the expert feed into it, but the credibility first and foremost. I mean, you want the expert to be legitimate in their field, and you don't want there to be any question about that. That includes like their CV type information, their education, their experience. The example I gave you guys earlier of the head of the dermatopathology unit department at the Harvard Teaching Hospital. Like, I really enjoyed, I didn't try the case, it settled, but I really enjoyed talking about the fact that I had, the head dermatopathologist from Harvard who's going to come and offer the opinion that the defendant in that case, breached a standard of care. So sort of like the gravitas and presence of the expert, I think, lends to the credibility, and that's something that you should be evaluating. I mean, really, let me step back from that. I think from call one, or your very first interaction with an expert candidate, you should be putting yourself in the jury box and examining this expert as if you were a juror deciding the case. And I think that if you frame your inquiry from that vantage point, it's going to be hard for you to go astray. So I think it's a really good way to approach it. Thoroughly research your candidates. I mean, you probably did a lot of that if you were using the Google method or the Westlaw Lexis method to find candidates in the first place. But like, I think that it's worth going to the ends of the internet to find out what's out there on these candidates. Use Google, look for YouTube videos, that can help you evaluate whether or not an expert would be good. I mean, if they were, if you are a plaintiff's lawyer, and this particular expert, gives a talk every year at the DRI convention about, malingering plaintiffs, well, maybe that's not the right fit for your case. Or, you find a YouTube video of a doctor, sort of a bio interview from his hospital profile, and you can sort of evaluate how he explains a very basic concept and whatever his specialty area is. Well, then maybe that's helpful to you, because you can say, wow, I really like his presence. I like the way she explains that concept. That's check in her favor. Thoroughly research what's out there. Obviously, you want to look to see if there's been any successful Daubert challenges or courts that have limited that particular expert's work, disqualified them. Like, that's something you want to know. One thing that I think is helpful, a practical tip for you if you're looking to hire a medical expert, is to look at their clinical setting, look at their patient reviews. I think that's helpful if they've got a lot of good patient reviews, whatever. But I think really if they've got a lot of really bad patient reviews, or certainly if they've been sued for malpractice before, that's something you want to know. So really do your research on these candidates, I think, before you even speak with them, and help you whittle your list down. Find deposition transcripts. You can't, I mean, a lot of times those are available on Westlaw and Lexis through their expert finder tools. Take the time to look through those and see how, the expert handles himself or herself in depositions. Publications that are out there. You just want to feel like you have an understanding of all of the publicly available information out there about a candidate before you make the decision to bring him or her on board. Litigation experience. I think these are some just the basic questions I end up asking really once I get on the phone with the expert for the first time. How many cases they review in a year. The ideal answer to that really depends on what you want. Sometimes I think it's helpful that if the expert doesn't really do a lot, you want to have done, I want my experts to have done some litigation work in the past. I don't want to be, I don't want my case and my client's case to be how they learn to become an expert witness. Like, I'm not interested in that. But I do think it's really valuable to have an expert, that only does a couple cases a year, or he or she's only looking at, 2 or 3 cases at a time. I always ask that question because I like to understand the expert's explanation as to how they fit in their litigation legal work with their own professional obligations. If it's a medical professional, I'd like for them to be in the clinic still, so they're still treating patients. I think that lends credibility to their testimony when I'm going to come in and have them opine about the care provided by a defendant doctor. I also think it's helpful, I always ask if they've testified for both plaintiffs and defendants. I don't shy away from that. I think if that you want your expert to come across as credible, and you want your expert to come across as having objectively reviewed the case, and it's just you really offering opinions based on the information that was presented to them. And so I think that it's really helpful and powerful if your expert can say to the jury, I do 5 cases a year, whatever, it's 10 cases a year, and about half the time I testify for the defendant, and other half of the time I testify for the plaintiff. I think that I like that dynamic when it works. I mean, there's obviously some types of experts that really by nature would only testify for one side or the other. But I think when it works, it's helpful to have an expert who does work for both sides. Ask the potential expert how many depositions that they have given, where they've given those depositions, how many times they have written a report for a federal case, how often they do that, what their procedures are for preparing those reports. Really understand how experienced they are in the litigation setting and how they approach it. I think will help you determine whether or not the expert is who you want to retain for your case. Obviously, how many times they've testified in trial, if they've ever testified in South Carolina. You just want to have a really good sense of that particular expert's background. For the most part, experts are really willing to answer those questions. But I will say I've had some experts in the past who get a little prickly about, they feel maybe like I'm, questioning them too harshly. But, if you get that sense, then it's probably not the right fit. You are obviously, advocating for the very best interest of your client, and you are going to bring this person on board as a valuable team member for their case, spend lots of time working with them, spend lots of money to have them on the team. If you get the sense that they don't like you asking very basic questions to evaluate the fit, then like that's an easy way to strike them off. Okay, yeah, so the next way to evaluate the case, I think, is so important. And this is one of the primary reasons I think that it should be you or the first chair lawyer evaluating the expert before you bring them on board. The ability to teach, right? You want your expert to educate the jury. So you can have the head of whatever department at Harvard, or like the top engineer from Goodyear, whatever it is. But if that super qualified, super smart person cannot explain very technical, complicated concepts like a high school teacher, then they're not going to help your case. You've got to find experts with the ability to teach. During the case, as you're putting the case together and building it for trial, and absolutely to teach the jury. And if that's not there, I don't think anything else matters. So I would like circle that one and put a star next to it. Like, that is a very critical factor in evaluating your experts, is their ability to teach. What I've found is great is if you can get somebody from the academic setting, from a university, who is in the classroom teaching students for whatever reason. Those experts a lot of times just seem to be really good at explaining, well, not for whatever reason, because they're paid to teach. So you bring them on board to a case, and that skill, it just pays dividends for you in your case. So don't diminish the importance of that, the importance of that role that the expert is going to play when you're evaluating who to bring on board. Availability, and this really sort of gets into my next point, which is how to communicate and work with the expert after you've got them. But for example, there's a lot of experts out there that do a lot of expert work that, you'll call them and ask them to take a look at a new case. And they'll say, sure, I can get to it, but I can't get back to you for, 12 weeks. Maybe that works for you, maybe it doesn't, but you need to understand their availability, and you need to also understand what you need from them, because you don't want to be rushing around, to get the expert to sign off on an affidavit. And, you don't want it to be rushed unnecessarily because you didn't understand their availability. If it's an expert that, needs to meet with your client or evaluate your client, or needs to go to a site and inspect or, review a product, you've got to make sure that what they can offer you can fit in your timetable. Geography. So this didn't really used to be a big factor on my list, but I thought about it just because I heard a defense lawyer say this, and it landed really well when he said it. And he said, they had to go all the way to California and bring this lady from the West Coast down to this courtroom in South Carolina just to find somebody who would say that this particular defendant did something wrong. And I just thought it really landed well. I mean, I think there's obviously counters to that, but I think it's worth thinking about geography, again, from the standpoint of credibility and how the witness is going to appear to the jury. You want them, again, to be objective and, work on the presentation of bias, location, all of those factors going into ultimately the presentation you want to make at trial. So I think geography can be something to consider. It's just definitely something I've thought about since I've heard that lawyer say that. Cost. So you obviously know that experts are expensive, and make sure you understand how much. It's hard for the expert to predict. It's hard for you to predict like how much all in it's going to cost. But if you've got an expert who wants to charge you, I don't know, $800 an hour to review documents, and then a $10,000 a day flat fee for a deposition, or $20,000 to come to trial, maybe that doesn't work for the value of your particular case you're working on. Or Maybe it's the perfect expert and, you really need to bring this expert on board, but they're so expensive. Well, that's maybe the time to reach out and get some help from another firm to help you fund the case and work on the case with you. I mean, we do a lot of that here at my firm, just because we're able to invest the resources. You can spend north of $100,000 working on a complicated case on experts and getting that case ready for trial. And so I think that cost is a huge factor in bringing the right expert on board. So, make sure you're thinking about that. Again, what your particular case needs, or if it's the right expert, but the cost is prohibitive, maybe that's the time to associate another lawyer to work on the case with you, that confront those costs for you. But again, I think those are all really important things to consider as you evaluate experts and how to identify who you want to use. Working with experts. The key to working effectively with this expert that you finally got on board and you're going to be paying all this money to is organization. And I think that that's the key to litigation, really, right? Is organization and preparation. I mean, that's how you outwork the other side. But I think you really can maximize the value of your expert if you are organized about it and thoughtful about it from day one. And so that's really what I'm hoping I can offer some thoughts about that to you to help you, think about how you've been working with experts in your own cases. Plan ahead. So when you get the expert on board, come up with a plan for what you're going to need from that expert and when you're going to need it, and share that plan with the expert, and then stick to the plan as much as you can. I like to, as I'm evaluating, and then when I have that first call after they're on board, ask them, I've got 1,000 pages of documents I need you to review. Can I send them to you now, and we can schedule a call in 2 weeks or 3 weeks or a month to discuss your review of those documents? And go ahead and, if you can, get that date on the calendar, at that initial call, or, a month out. Or think about the things that, you're going to need the expert to do before they can be really vested in the case for you. Does that include a site visit? Does that include inspecting a product or the car or whatever it is? Does that include meeting with the client? Does that include evaluating the client and, testing the client and generating some sort of report or finding or, impairment rating or whatever it is? Does that include reviewing information that really hasn't come up in discovery yet? Like, for example, if you've got an economist expert on board, and the other side hasn't asked for, financial information of your client, well, figure out what that expert needs early on and get all of that information gathered to give to your expert early, or to ask them what they need and make a plan for how you're going to get that information to them, and then follow through with it. It's just so beneficial to you and your own stress level and your own, we're all busy. I don't know that many of us are lucky enough to really only work on one case. So, you've got a lot of different cases. Plan ahead and stick to the plan. Will be appreciated by your expert and certainly will help you manage putting the best possible case together most efficiently. I think it's important to keep your expert in the loop. Update them on deadlines and demonstrate that you have an appreciation and respect for their time. Like, what I mean by that, this came up for me last week with a life care planner. If you've worked with life care planners, then it's a very, very involved process to put together a proper care plan. It involves, reviewing records, speaking to treating physicians, speaking to the client. And it is a project to get that plan, in final form to be produced. So I had this come up last week where it's a federal case in North Carolina. We had our scheduling order extended. Well, so the first thing I did was reach out to my life care planner and I said, hey, I know you were really working hard to get this done by X date for us. Well, we just got an extension. So I wanted you to know that. And is that something I had to do? No. But I think she really appreciated the fact that I took the time to do it. It helps her manage her own practice and her own work in a way that, hopefully keeps my case in the forefront of her mind, and she appreciates the professional working relationship I have with her. So keep the expert in the loop. If something big happens, let the expert know. Understand and honor the expert's work preferences. Just do it. If the expert wants to talk to you at like odd times, make yourself available. If your expert wants, 5,000 pages of medical records printed out and shipped in a box, it's probably expensive, probably annoying. Just do it. Make it as easy as possible for the expert to do his or her work on your case. And don't forget when you're working on this planning ahead and keeping the expert in the loop and the organization of the expert's role on your team, that these experts may not be familiar with our local rules, our jurisdictional rules. And what I mean by that really gets to the communications, right? So in federal court, the back and forth communications we have with our experts and draft reports are pretty much protected from disclosure. State court, not true. It's all fair game. They get the communications, they get the emails, they get the draft reports, but your expert may not know that. Okay, so don't take that for granted. And I had a case, we ended up turning it down, but it was being reviewed by an expert, and I told him on the phone, I said, don't put pages of analysis in an email. Pick up the phone and call me and let me talk through it, because let me make sure you've got the facts that you need before you make some decision and commit it to writing. Wasn't familiar enough with the reason I was saying that, and just put a bunch of stuff in writing that I would not have otherwise wanted committed to paper. So make sure your expert understands the court rule, whatever court you're in, the rules of that court, and also make sure your staff know that those rules as well. So if your paralegal's emailing the expert, to set up calls or whatever it is, make sure that your staff is aware that all communications in South Carolina State Court are subject to discovery. Okay, I think I'm running short on time. So how do you use the expert, communicate with the expert once you've got them on board, you've got your plan in place? How can you really use them to maximize the value? You've got to talk to them. I don't know how many times I've talked to friends or other litigators who, they do the work to get the right person on board, and then they have them sign an affidavit or not, depending on the expert's role, and they don't talk to them again until a week before their deposition's being scheduled or being set. I think that's a misstep. I think you should be in the habit of filling your expert in on the case along the way. I try to make a point to reach out to experts, particularly on my bigger cases, every 60 to 90 days, just to let them know what's going on procedurally with the case. If I found out anything new from a deposition or some piece of information that we were really looking to figure out, talk to them, help them keep your case in the forefront of their mind. I can't overemphasize that enough. Don't just fill the square, get them signed on, and then move on. Keep them as part of your team. That's what you're paying them for. Spend the extra money to set up that extra phone call. It's worth it, which really leads to the next point. Learn from them. Don't be afraid to be a student as to the subject of their expertise. You're never going to be, most of us are not going to be mechanical engineers. We're not going to be chemists. We're not going to be economists. We're not going to be, medical professionals. Let them teach you. That is what you bring them on board for. Something that I've done recently that I really like is I ask the experts for articles and textbooks or chapters of books that I can read and review. And then I do those things. I read them and I review them, and I try to learn as much as I can about that subject of expertise. And I'm not afraid really anymore to seem like a student. And I think that's helped me really develop a good rapport with experts I'm working with. But there's a caveat to that. They know the expertise of their subject area, whatever it is, but you need to be the teacher as to the facts of your case, right? The best expert in the world is only going to be good for you, good for your case, based on the information that's been provided to them. So make sure they know all the critical pieces of what's going on. Like send them all the medical records and they can figure out what they need to review or not. Send them all of the document productions and let them, review pertinent pieces of it. Send them a depot transcript and say, hey, take a look at this, call them and say, take a look at this section where the witness talks about the condition of the factory at this point. Tell me what you think about that. Teach them the facts of your case. Don't just expect that they know as much as you do about the facts of your case and your client, because they don't, right? If you've got the right person on board, your case is not going to be the only thing they're working on. They're going to be in the clinic. They're going to be reviewing lots of other cases, whatever it is. Teach them the facts of your case, and don't let your role as a student, as to the subject matter of the expertise, like take over and they're telling you about the facts of your case. That is your job. Master the facts with their help to understand how these principles work together. One of the last things that I can't overemphasize enough, I probably should have made this the first slide, is prepare. Like that, we all know that. It's very important that you don't take the basics for granted. And I'm gonna give you an example of what I mean by that. You have worked so hard to understand, what went wrong, with the way this particular tire was designed, or, what happened with this patient in the emergency room, whatever it is. Like, you jump to the meat of your case, but then you forgot to prepare the expert on some really basic questions, and they will be asked those in their deposition, which is why you got to prepare for that deposition. What is the standard of care? Right? And so I had that recently. Luckily, it wasn't my expert, where the expert fumbled through that question. I think he ultimately knew the answer, but he just wasn't prepared for something that basic. It's very basic to us in the legal setting, but again, maybe not as basic for somebody who doesn't do what we do all day, every day. So prepare and don't skip over the basics. Make sure your expert's clear about his role, right? Is he offering opinions as to all the defendants, just one of the defendants? How do you want him to handle questions about, when he's asked about defendants who aren't the subject of his review? Prepare him for that answer. Let him defer to another expert, or let him say he just doesn't have an opinion. Don't prepare him so he doesn't give you a bad answer that you can probably overcome, and it's not that meaningful, but you would have preferred him not to offer it up, right? You cannot prepare too much. I think, experts' time is expensive, but I think it's absolutely worth it to set up a couple of different sessions before that expert's deposition to walk through the case, even if you repeat it a couple times, so that they're fully up to speed on the facts of your case. They're fully prepared on, some of the basic questions that you assume they know the answers to. Make sure you have dotted every I, crossed every T. And I think you'll get a lot more out of your experts in their depositions. I think I'm running really short.
So let's open it up to questions. If anybody has any, they want to put in the chat.
Let me let's see if I can get out of the. Oops. Okay.
Oh wait, here's one. In state court, how do you protect your case analysis that you might want to give to experts from discovery?
I mean, I think as a practical matter, if you put it in writing, give it to the expert. I don't have a lot of good tips for you to keep that protected from discovery. I think the best way to do it, if you want to think through your strategy with the expert, is to get them on the phone and discuss your approach to it. Would be my immediate answer to that. I mean, there may be a way to do it, again, depending on the particulars of your case, but the best way to, and again, the phone call itself isn't protected from discovery, but at least it's not you putting in writing, here's my strategy as to this point, here's what I think as to this, in a written communication that will then get produced. So I think that I would do it over the phone. Or I mean, ultimately, you want, in the best possible world, the expert's going to arrive at the same conclusions that you have based on his or own truly objective review of the case. And that is dynamite. When you don't tell the expert anything, other than the very basics of the case, they review the records or whatever it is, and they come up with the exact same, strategy that you've been working on, or the exact same theory you've been working on. That's gold.
Well, I think that was the only one. So thank you, Julie.
Yeah, absolutely.
Really
Anybody
appreciate it.
reach out at any time if you want to talk about expert work or your cases. I love talking about it. So thank you so much for your time today. I hope everybody has a wonderful Halloween and stays safe and healthy. Thank you.
Okay, we'll take a short 5-minute break or so, and then we'll get started with Dr. Gray and Dr. Albano. Is that fine with you two? All right. We'll shoot for 3:20 to start.
Good to see you, Kevin.
Likewise, nice to see you. Hopefully we can find time to catch up tomorrow as well. Although, yeah.
I'm flying in the early afternoon, flying back to New York.
Got it. And then 2 weeks.
No, only one this time.
Oh, good. Okay.
I just want to be home next week with various things that are going on
Got it.
in the wider world.
Got it. Oh, yes. Oh, understood. Understood. It is, yeah, I try to force out of my brain anticipation of election, et cetera. So.
Mm-hmm. Yeah, that's all I've been doing interviews on like this past week is how to manage your election anxiety. You know, number one thing, you're not changing Uncle Ned's mind at this point, so whatever.
Yeah, this is no time for us to, argue with one another, which I know we're doing a talk Monday, I think, later.
Oh, why are we doing that? Yes, that's right. Oh, we are live. Thank you. Yeah, we know.
Thankfully not discussing anything confidential, but thank you for the reminder.
Tio, we have done one check-in today. We're about to do another one in the middle of this one. Okay. All right, well, we can get started a little early. We are here with Dr. Gray and Dr. Albano from the MUSC Health. They're here to talk about balancing the scales and managing your emotions in the era of COVID-19, a primer for attorneys. You're both showing as mute, or Dr. Gray, they are. Okay, all right, we're good to go.
Okay, great. Well, thank you so much for having us both. And I can start with just self-introduction. I'm Kevin Gray. I'm a psychiatrist on faculty at MUSC, and really feel privileged to be able to talk with this group today, and also extra privileged because I get to speak with Dr. Albano. So Anne-Marie Albano, who is with whom I've gotten to work with a new endeavor. It's a partnership between the BMOC Family Foundation and MUSC called Modern Minds, which is a new mental wellness program, which we can talk a bit more about today. But also, I'll let Dr. Albano do introduction as well, and we'll proceed from there.
Thank you. It's very good to meet all of you. I'm not muted, right, Kev? You can hear me?
I can hear you.
Good. Very nice to be here with you all. I'm Anne-Marie Albano. I'm a clinical psychologist and the executive director of Modern Minds, which is this new endeavor, a joint venture between the BMOC Family Foundation and MUSC here in Charleston, where we're focused on anxiety and depression in working adults. At the same time, Kevin and I each have a long history of working in the field of mental health and dealing with stress that affects all of us. And not for anything, but the prior talk that I caught the end of being an expert witness, boy, do I remember those days when I used to do a lot of that. It was a little stressful. We all go through stress. And so, especially during this prolonged and unprecedented time with COVID-19, we want to talk to you all and maybe offer some help, insights, whatever for you to share with your clients, your family, yourself, on how to manage. And of course, as you know, we were sort of talking offline but live, you know, even with the elections, things that are going on in the world affect us. But COVID itself gives us something much more unprecedented and unique and once in a lifetime, we hope, no more than that. When we look, I mean, I don't know, you all are attorneys, maybe you've read things like The Diary of Samuel Pepys and other historical biographies and such that capture key times in history when plagues or various kinds of things like that hit certain areas. Now that's from the 1600s. We used, you know, and I'm sitting here thinking about how do we handle COVID? The only things that we have for something of this kind of a scale of real devastation that's worldwide are by looking at back to the past as to what were the plagues of old. But it's different now, obviously, because, you know, you don't just get the people who can go to their country estates and wait for things to pass. We're a global world with people traveling all over. It's hard to contain these things. We have to look at what in our more recent history helps us and what kind of mentors, if you will, stand out who have left us information for learning how to cope at a time like this. And so Viktor Frankl is a survivor of the Holocaust, which again, unprecedented traumatic event. And that was a prolonged trauma and event. And, you know, he helps us to understand that an abnormal reaction to abnormal situation is a normal behavior. And so the things that may have been going on for any of us over this time since March, we're all dealing with something that is frightening and threatening, not well understood. And so we should expect that, you know, we may not be ourselves and the people around us might not be themselves for a period of time. And when it comes with COVID-19, the thing we want to understand too is, you know, Dr. Gray can talk about this. There's a medical footprint that occurs when there's any kind of a disaster. And those are the things, of course, when you think of images of 9/11 or you think of various things from a tornado and such, there are definitely, you can see certain medical issues that happen to the people who are in harm's way. When it comes to a disaster too, though, there's the psychological footprint that occurs on an individual level and also in families and on the group and community level. And as we see too across the country. And that is not readily understood. It's not readily recognized in a lot of ways because everybody deals with emotions and their reactions to things very differently. So we have to be aware of what's going on right now for a prolonged, not well understood, unprecedented disaster like this, is that it's novel and we're learning a lot. It takes science a while to catch up, that there have been and continues to be quarantine and isolation and people who are kind of stuck. And I got to say, I'm with MUSC and Modern Minds, but my primary employment is through Columbia University in New York City. So tomorrow I fly back. This is, I think, since June, the 6th trip I've made here, where I fly here, I stay a couple weeks, I fly home, and I'm in quarantine for 2 weeks, and then I come back. And we've got to be ready to roll with these things. Kev, do you want to talk about more of what we deal with?
I'm going to say, you know, I'm a fan of imperfect metaphors, and one of the things I think about in unusual and abnormal times is, in some ways, it's almost like a lot of things stay covered, our vulnerabilities, and sometimes our factors of resilience remain covered. We don't even recognize them. But thinking about unusual times is like there's a record low tide. And so things that you never really saw before now get exposed. And so people who may have been somewhat vulnerable becoming anxious or have a difficult time with social isolation and get more sad and down, or people who get or irritable or substance use or things like that may have been kind of under the surface, sometimes kind of surfaces some of these vulnerabilities, and something that was maybe a characteristic can become problematic in abnormal times. So sometimes we see things we wouldn't have otherwise seen, which I think in sometimes in a good way helps us to understand that there's a continuum in terms of people's wellness and illness, rather than this clear category of like, here are those who are mentally well and those who are mentally ill, and recognize that commonly among us, especially around something that impacts all of us in some way, is it helps us to understand folks who have struggled with depression and anxiety and other symptoms and substance use and other things, but also we recognize our own vulnerabilities. So I think that's helpful for empathy, but it's also kind of a marker of just how pervasive this can be in unusual times, which is part of why a talk like this may be important to think through some of this.
And this is a little out of date because I put this up last week, but the sequelae of COVID-19 is something that we're going to be managing for a long time. Right now, as we know, that again, we're going through a period of an upswing and surge to a degree here. We'll see what happens with cases. There's a lot going on that folks are managing and dealing with. And you as attorneys, I'm sure, are being brought into all sorts of aspects, not just of the universal feelings that we have around people that we have heard have it, who has been lost and various such, but you're also dealing with the aftermath when, I'm sure, within homes and families of your kids' milestones, they're not celebrating their graduations in the way that they would, or various things, job changes and job losses for people that the bankruptcies and foreclosures that are happening, and so on. There's sequelae that we're seeing right now that are in front of us, and things that are going to keep going, and that we'll be experiencing more of in different ways as time goes on. One of the things we need to know is that after a natural disaster, and here, again, what we have in our lifetime to look at are tornadoes, hurricanes, floods, natural disasters. About 10% of people will develop a psychological problem that may be anxiety, depression, or post-traumatic stress. When we look at viruses specifically after SARS, we did see PTSD, post-traumatic stress disorder, happening in folks. It was more common for people who were at high risk for a specific reason. High risk in that they were more isolated from getting support and help for one reason or another. Those who had lost loved ones, and specifically, in a traumatic way, not being able to say goodbye and various kinds of things. Those who are at high exposure or quarantine for long periods, and we especially look at disadvantaged populations where you have a lot of people cramped into small spaces, let's say in certain housing types of situations, multi-generations together and all, where there's not a lot of space and people may be infecting one another and such, those kinds of things, folks in abusive relationships who are stuck. So those are some of the people who are at risk in the communities. And we are seeing from right now, at least the medical outcomes in terms of deaths and all. We know that more vulnerable people are the ones who are getting hit hardest, but then we think about their families too as being exposed firsthand to those losses. And then finally, our medical healthcare workers and those who support them, the janitors who go in and clean up isolation rooms and such, and those who are on staff. These folks are at highest risk for some psychological or mental health outcome, as well as, again, Black, Hispanic, and poverty-stricken individuals. So we want to keep an eye out on those folks. This is just a general survey from the Kaiser Foundation showing that from March, April, May, into July, just in general in the United States, there's been increased stress reported by people since the impact of COVID. And all indications that we're seeing in other surveys that are coming out now and more recently is it's continuing to build.
I think there's different, oh, go ahead.
No, go ahead.
I was just saying, as part of it is there's the acuity part, and that's the part that's sort of like a hurricane, and then, okay, well, we're going to recover. And then there's the chronicity part, the uncertainty about how long. So that's sort of why there likely is some of this wavering, but kind of continuing where it's sort of setting in that this is something we'll be wrestling with for a while.
And certainly, we don't want to be the bearers of bad tidings here, because there is another side and silver linings to this. Really, most people should be resilient to the psychological stressors and impact of COVID-19. And this is what we want to talk about and emphasize through the rest of this, is how to talk to your loved ones and the people you're working with and such, and also for yourself, how to understand that resilience is really the most, that's the fundamental coping result that we want. If you use strategies for taking care of yourself. And a big thing to recognize, when, especially for those who are working on the front lines and those who have lost their loved ones during this this period, expressing positive emotions, while you feel like you can't and you shouldn't, you know, feel good or have a good experience during a period of mourning or something, actually that is healthy, and it's a part of the mourning process and a part of recovery. Positive emotions have shown to really lead to greater abilities to be resilient during times like this. And part of it too is that helps us to look at, okay, what's our purpose? Why really are we committed to the things that we have committed to, being attorneys or being as we are in healthcare? You know, why are we doing that? Why are we family people and such? What does that mean to us? And how do we want to renew not just our commitment to that, but the way that we approach all this? So this is all part of what we want to look at in the silver linings. And COVID, though, we know is not the only thing going on in our life. So, you know, in balancing, you know, the stress of COVID with your everyday life, we also know we're living in a country that has a lot going on, some of it from COVID, some of it from other factors and such. And so this isn't, you know, just a time when we have to deal with one thing at the same. There's stress around the election. We all know that. As Kevin and I were talking early on, and maybe you have heard, you can't convince Uncle Ned to change his mind for your candidate at this point, you know, and there's stress that's going on. We know that with George Floyd and other acts of brutality and racism and such, there's a lot of stress and tension there, and especially within our communities that we need to look at. COVID and other reasons, work and the economics that are hitting not just, you know, people on the front lines and restaurants and in our grocery stores and so forth, but, you know, all the way up in our larger corporations who's been furloughed, various things. And then how many of you are managing this, you know, kids being at home and being schooled while you're trying to run your practices and businesses and so on. Your college kids are coming home. All of these things are with us and are going to be with us for a bit of time.
And recognizing that there's, you know, one of the things is knowing that all administrators in charge of things like schooling, in charge of workplace environment, in balancing productivity, education, et cetera, with safety practices, is also dealing with uncertainties and is trying to balance things as best as possible. And in a charged landscape, it's easy to criticize, but it's also really hard to be in those positions. So one of those thoughts about being empathic about complicated decisions and with where there will always be some risk and challenge with it, and realizing that that's going to be an evolving thing over time as again, as the science advances, our ability to medically manage advances, but at the same time, we're in a heightened state of stress. So it's another one of those things where I think it's trying to step back and trying to be empathic around difficult decisions people are making at the individual and at the collective and organizational level.
And one of the things, and we just want to focus on for just a second here, is that, you know, for any of us, we always have to think about what is it like to walk in another person's shoes. And it's hard to do that if you're not similar to the other person. And one of the things that happens, and that we've come across in a lot of the work that we've been doing with folks, especially of late, is that, you know, especially white Americans don't talk with our children and with our colleagues and, you know, about racism in the way that Black Americans do, and they do at a very early point with their kids and such. So it is different for us. We need to ask each of us, where are we in terms of our role in the places that we work, in the system, in our communities, for what our thoughts are. How can we let our colleagues of other races know that we're here to listen, because that's the most important thing for us to do and to learn, and how to help give rise to voices that help within our organizations, again, promote diversity and equity that maybe can be transferred to the community where it's needed and such. So all of this goes to the bottom line that we want to talk about self-care. At this time, it applies, self-care applies as a way of really being resilient, but also protecting against the stress and strain and the psychological effects of any kind of major stress that hits, from COVID to things that are life and involved with community and part of living in the country right now as we are. This slide just looks at, in a typical trauma, and look, geez, Charleston is not immune. You have hurricanes that you deal with, floods and stuff. In a typical trauma, you got a little bit of a warning, but the disaster may happen. There's an impact. And here there's the heroic phase. And again, as being in New York City, the heroic phase is where we were recognizing, and New Yorkers were coming out and clapping every evening at 7 o'clock for our healthcare workers who were staying on the front lines. And then comes where the communities are banded together. We also saw this in New York after 9/11 and such. The community really banded together, and as a country, we banded together. But the longer things go on, the longer this period from, the heroism is recognized, but then it's prolonging. There's all kinds of things that can make things go up and down for disillusionment. Unfortunately, with COVID-19, this is a very long phase for us. We are not yet at a phase of reconstruction. And, science and politics, unfortunately, are clashing, but they've got to get together at some point that they'll be working on what this reconstruction looks like. But bear in mind that, y'all, we're here. We are here. And so it is a time when we have to ride the waves of stress and things that are sent at us, ride them while not falling off the board into the ocean and drowning in the stress that is out there. Kev, do you want to?
Yeah, and this slide really kind of gets it to the suggestion I was making with the imperfect metaphor around ultra low tide, and recognizing that stress is something we all experience every day. In some ways, stress is actually it's important for us to have because it drives adaptive behaviors. If we weren't under stress, we wouldn't do goal-directed activities. So stress sometimes drives us and motivates us well, but we also recognize that under unusually high stress conditions, sometimes we are not able to react adaptively. And so this kind of gets at sort of categorization across a spectrum as stress being a normative human, this is something that is necessary in our physiology, but then getting to distress, which is the idea is that when things are unusual in our circumstances, which then becomes more severe based on circumstance. So you may be somebody who may be very adaptive at managing stress, somebody who doesn't show much, but an unusual situation can bring that more. But then you could also be somebody who's more vulnerable to having a severe stress reaction and then also faced with a distressing situation. And that's where you get into more of a disorder phase. And again, I think as a culture, we often try to categorize people as well or ill. And so I think it's, the phenomenon, the diagnosis of PTSD, post-traumatic stress disorder, is now well recognized. But even that occurs along a continuum because there's vulnerability genetically for various psychiatric conditions, and there's also environmental antecedents that bring those about. And sometimes those two things mix and people meet criteria for disorder. But the reality is that this all speaks to universal human vulnerabilities. And understanding is that even at their best, people are prone to going from stress to distress in an unusual situation. And we also have to think about people who may have a pre-existing disorder like PTSD, and then you add trauma to that and the burden of that that kind of continues from here. But sort of part of the thought is that allowing, especially if people are thinking through their own way of navigating the current times, is that all of us has some vulnerability, but understanding that some of that just has to do with we are reacting to an unusual situation, and our stress response sometimes can be used adaptively.
And then, this again, we don't want to beat this to death, but this is where most of us are going to be. But recognizing, again, we have to take a look within ourselves and again, within the people that we're most closest to. Distress reactions, look, when the stress of having the kids at home, the kids are feeling the stress of not seeing friends the way that they're used to, or being able, like, here's Halloween coming, are they going to be able to go out and trick or treat and mix it up the way that they do? When these things are happening, take a look and you have to think through, are your changes in sleep occurring? Do people feel less safe? They're getting more physically upset, headaches, stomach aches, and various things. Do you find that your kids, the people you work with, are being more irritable or distracted? And then the isolation and avoidance. These things contribute to distress reactions. Now, some folks jump to risky ways of of trying to tamp these down. And risky ways are everything from, smoking more pot, what have you, drinking more, taking more medication than you're prescribed, or taking, drugs that are not prescribed for you, disruption, you're calling in sick more, various things. Also for others, there could be reactions just occur in terms of violence, or if there's history of that happens more often. When this happens, then we cross over into psychiatric disorders. And we really, when these things are going on too much and it becomes a pattern and they're not letting up, we have to take note of whether an individual or needs intervention and help. So the question that we really do want to talk about now is, what do we do with this? How do we cope? And just so you know, this is my go-to pack for when I come back to Charleston. I go back and forth. I have my goggles, my N95, I got everything. It's just one of the ways we're learning to adapt. And while we're learning to adapt, the big thing that really nags at us all the time is that we have to learn how to tolerate the uncertainty of when things are going to get to a new normal, when we're going to have answers that we're seeking. Will there be a vaccine, and when will it come out, and how is it going to get to the people? Or will there be therapeutics that really help to the people who are affected? There's a challenge for us in tolerating the uncertainty of what's going on. Or how with these surges are we going to have more, a run on the paper products in the stores? Are our kids going to be tutored at home and having to do virtual schooling? And how's that going to impact me for the rest of the time I'm trying to work and get my job done? A big thing for managing anxiety and stress and such is tolerating the uncertainty and not having the answers and being okay with that. Kev?
Yeah, no, I think we are designed to seek out patterns and routines. And when that's disrupted, and particularly when we don't know when the disruption ends, is challenging. So it is one of those things is that, okay, so if I just know an end date, if I can just see the light at the end of this tunnel, I can make it through this time. What sort of doubles down on the stress is sort of the not knowing when. So it's like, okay, well, all right, so I can work from home while also managing my young child who also has to school from home. I can do this for a little while, but when does that change and why? And how can I contribute to that? That adds to that. And then part of it is figuring out, okay, well, how can I flip that and recognize, okay, I won't know the answer, so I won't know when that's coming. How do I self-manage when there's uncertainty? And that's a bigger challenge, but I think we have to sort of be in that mindset. And I know I fell into this trap a good bit in terms of managing a clinical and research team is, okay, well, we're going to do this modified thing for a while, but then when it's back to normal, we're going to go, but we sort of said, okay, well, you know what, even when it gets back to normal-ish, we're learning to become adaptive to a new situation. And so some of the things would be like, so if there's a hurricane approaching, it's not school or no school. It's, well, okay, when do we do virtual school as an option? So we've adapted. That's a good thing. But some of that stuff is just understanding uncertainty, but also picking up the things that we've learned in unusual situations.
And the thing we have to bear in mind too, when we talk about resilience, when I used to think of resilience as snapping back to the way we were, kind of like a rubber band. We're being stretched during a period of stress, but boom, we're going to be back to where we were. Well, actually, we learned that, people do change as a result of, and situations have to change as a result of. I mean, anyone who has lost a home during a hurricane or such, we know, you rebuild if you can and where you can and stuff, you have to adapt. These are hard lessons a lot, but if we understand that resilience means it's going to take time for us to feel settled and to get things in order again, and that's comfortable for us. And we have to be engaged. We can't sit back and just let it happen. We have to be engaged to cope and to problem solve and to manage things. And we have to have patience, because nothing will be fixed and solved quickly. So all of this, is just to say resilience is being able to roll with that while actively engaging and doing things, again, that comfort and soothe you in the process of getting to where you need to be. And, you know, it's kind of nutty. To think about this, and it sounds maybe a little trite. When you get on an airplane, they tell you to put the mask on yourself before you put it on your kids. But this is the truth. We have to focus on self-care as adults, as in head of household, or, you know, partners in a household. You've got to focus on your self-care before you can take care of those around you, whether they're your kids, your partner, spouse. And when I say partner, your partners in the law firm, your associates, your clients, you've got to take care of you first. So this is a big thing. Number one thing is really, you've got to check how have you been since March? Have you experienced emotions that aren't typical of you? Have your spouses or your business associates told you, like, gosh darn, what's with you? You know, you're more irritable. Are things showing up for you that weren't there as consistently as in the past? Or maybe, well, once in a while, but this is critical because we are, you know, running on maximum power in a lot of ways, and we've got to learn how to power down and notice what's within us. And an important part of this is accepting that, you know, we're human, and these emotions that we may be experiencing are human, natural, normal emotions. And so trying to squash them and deny them is not going to be the way to help you. You've got to accept them and be compassionate towards yourself, and then take care of yourself with specific things like making sure you get sleep, making sure you do things for pleasure, even though you're working on Zoom from 7 in the morning till 11 at night, and finding meaning in the way that you engage with the people around you. But the biggest issue is focusing on what is in your control within reason, and the things we can't control, again, we've got to ride out and say, okay, I can't control those things, so I'm going to do other things to take care of myself. Kev, do you want to?
Yeah, that gets into compartmentalizing some, because there's going to be this sort of this ambient stress that all of us has some exposure to for things that we don't have control over, but it really is, you know, one of the tangible things, and one that I've been imperfect at doing but keep striving to do, is on days that I'm not in the office but working from home. Well, hey, I've just knocked out a half hour each way of commute time. What do I do if left to my own devices and not thinking about it? I'll just work an extra hour, right? Or I'll work even more because I feel somewhat guilty about not having been in the office, and so I'll stretch the day out and blur the lines even more. But if one's really being intentional about it, the idea is, wow, I've just saved an hour where I was otherwise just fighting traffic to get to work, and instead I could be engaging in something that would be exercise, could be meaningful time with family I wouldn't otherwise get because I would grab a protein bar and head out the door. Instead, let's try to breathe for a second and have breakfast before we go on to our activities. But one of those things about actually being very intentional about it, rather than just falling into what you would do otherwise, that, you know, maybe doesn't make you feel better. And that's part of the idea of, like, it feels very selfish, the idea of taking that oxygen to yourself first, but you realize you're a better partner, parent, co-worker, et cetera, if you're at your best self. And so figuring out how to manage that time within your schedule, which ironically, in our altered lives, in some cases actually is more available than it might have been otherwise. Now, that's certainly not always true, but trying to find those opportunities, and not forever being in the trap of I'm always behind and there's never a good time to start taking care of myself. So, you know, they say the best time to plant a tree is 50 years ago. The second best time is today. And that's part of the thing about trying to self-care. And again, I confess I'm as guilty as anybody of, well, I'm just going to, I got to manage that email, or I got to take that call. I got to do this other thing. And I say, well, I just don't have time for the self-care stuff. And I'm not at my best self when I approach it that way. And if I can take advantage of those opportunities and schedule and be intentional, much better that way. And then Anne-Marie's got more stuff about managing stress besides just general exercise.
So you see these different ways of managing stress, and, you know, find for yourself meditation, mindfulness, and various things. Exercise and getting out is key. But a big thing for managing stress, and I keep moving Kevin around, sorry, Kev, is, you know, the number one thing that is going to help you with managing stress is a concept we call psychological flexibility. Now, I know you guys are lawyers. I almost married one. And I used to type up all of his stuff for law school. And the thing, you know, I know that, you know, there are rules and ways that we do things and following order and such. But a big thing here is being psychologically flexible when it comes to your health and wellness, which is you've got to give. We've got to give in various ways to stay present in what's happening to us in the here and now, and what our emotions are and what we're experiencing in the moment, in our sensations and such, but choosing behaviors then that are within reason that can help you to move through a difficult situation, and do that based on your values. So you live life with an intention. So this is very important. Psychological flexibility is you can't lock yourself into one-minded way of thinking. It should be this way. This is how it's got to go. When things are so out of control and out of everybody's control and so unpredictable, we've got to figure out a way to flex some things so that we can be healthy. And part of that comes with the idea, when we talk about anxiety, stress, and such, is that what gets at us is when we can't predict what's going to happen, when we don't know for certain when something's going to end or what. So to deal with uncertainty, first thing is you've got to breathe, and you've got to keep your focus and a deep, slow breathing going. And you have to identify what is it that you think is going to be catastrophic, or what is it that's going to harm, or what is it that's going to get you into trouble, or whatever stuff. And you've got to think, how likely is that to happen? What are there possibilities for me to manage this situation at this time? And look, some of the things that have gone on here in terms of the dealing with uncertainty. So I have a number of parents I've been working with who are, attorneys or bankers and various folks who can't get to their offices and can't get in for face-to-face meetings that have been starting to happen in New York, and then also the ones that have been going on here because they have childcare at home. And the worry is, what am I supposed to do? I've got to be here with my kids. I can't leave my little kids while they're doing their schooling that's virtual, but I've got to get into the office. Does that mean that I'm not going to be, promoted to partner? Does that mean it's going to be counted against me? There's all kinds of worry that's happening. Our teenagers are having, if I can't do my extracurriculars, I'm not going to have the college application that I want to get into the schools. There's all sorts of what if can go wrong because of COVID, because of things going on. But we have to think about what are some other possibilities. What ways can we brainstorm to get our needs met and to manage situations that are difficult? What resources can I access for help? If you go along those lines, instead of staying stuck with spinning all of the catastrophic ends you see to this, then you come up with problem solving. Then you can take control and manage things. And a big thing to do is you've got to engage in self-care along the way. Always important to have self-care along the way. So this is, really big. Focus on what you can control, your attitude, following recommendations, your kindness. And we will expand this, engaging other people who can help you, whether it's something with work, something with home, and let go of the things that are outside of that circle. Because if you can't control it, you let go of it so that you take care of yourself, and you know that you're managing in the best way that you can. Do you want to add anything, Kev, before we?
No, I think that's good. I realize we've got more content to get through, so I don't want to slow it.
All right, and then that's another thing that's been going on, of course, is some of us have lost family members and friends during COVID, to COVID, and also to the fact that other medical conditions continue. And so, cancer and so forth, there's been loss, and the losses that have happened. I mean, I lost my uncle early on, and we still in April, and we haven't been able to have a funeral or such, lost him to heart disease. So it's a traumatic time, especially for people who may be right in front of things that are going on. And so what we have to do when it comes to trauma and loss is connect with others and find ways of expressing what we need to in terms of the feelings that we have, share our experience with others who are there to listen and can relate and validate for us. And again, think about what we're learning from these experiences when they are traumatic, and think about commemorating the people and those that we lost and dealing with our grief and sadness. So there's got to be ways that, we mark for these losses as they're happening. And then also, if we can't get together and share in the way we normally would, to plan for these in the future. But leaving trauma and loss and grief just sitting and stewing is not going to help you to move forward. Actually can relate to other problems that'll happen down the line with a bit of what we call uncomplicated grief and depression that gets in the way, or complicated grief and depression that gets in the way of you being able to function well down the line. A big thing to recall or to remember is no emotion lasts forever. No matter who you know, who's the most angriest person, the most cranky person, the most, nothing bothers them person, whatever, no emotional state lasts forever. We have to recognize every feeling is valid. It has meaning for the person. Okay. And there are times of uncertainty, and we will be moving through as time goes on. Now, I wanted to put this out there for those of us who have families, those of you who have families, to remember something. This is probably where a lot of us are on here. Actually, I'm a little more over here. This is probably where a lot of people are. You're in the middle. There are kids down below. There are the family members up above. For the 2-year-old, the 5-year-old, the 8-year-old, even up to your 20-year-old, think about, as they're going through COVID, whatever age they're at, they have just lost a significant portion of their life to social distancing, lost milestones, not living the way that they were used to and thought they would if they went off to college or they went from middle school to high school. And so they're feeling these things like, wow, this stinks, because it's a big part of their life. And we have to validate that for them. It's true, it does stink for them. And then when we look at the other end of things, like for those who have real elderly parents and people who are, maybe retired and out, I have people I'm working with who are in their 80s and such, who are saying to me, is this the way my life is going to be now? Isolated until I'm gone. For them, while they may have had a long life, it's like, what does this mean now? Am I going to have anything left? We have to validate their feelings and help them too. And then those of us in the middle are trying to juggle it all and take care of everyone. We just want to say, when it comes to kids, you got to keep your cool and your anxieties and your emotions, recognize them, own them, but we've got to keep our cool, because one of the things that Kevin and I and our research has shown time and time again in our field is that parents' emotions will resonate through and be picked up by their children. Kev, do you want to talk a bit here?
Yeah, so I think that's the first part is always remember that we're modeling behavior for our kids, so they observe consciously, but also unconsciously. They pick up on patterns of how we behave and how we react to stress. I don't say that to heighten your stress, to say your kids are watching you and they're gonna, but just the general reminders of how we model for them, how you can manage when you recognize you're feeling stress, how you manage when you're not having a good day. And a part of it is so you're modeling that. At the same time, the other reminder for kids, although they tell you that they don't want structure and they want free time, kids really benefit from structure. And I think particularly early in COVID times, there was this sudden change from, okay, I've got this rigid school routine, but now I'm kind of on this Zoom thing and nobody really knows how we're supposed to do this. And the teachers are kind of scared to give full assignments. And so things were just sort of a blah weird, and a lot of kids have struggled in a lot of ways with that. Now, to varying degrees, that adaptation has happened for those who are distance learning, where there's a bit more structure, but we also know it's missing some elements. But the idea is finding the best proxies for the traditional structure that's possible. And that's not, in recognizing too, is that a big aspect of school is the academic learning, but we also recognize there's a huge social learning aspect of school that can vanish when we transition to online schooling, where there's not some kind of proxy for social interaction beyond social media, which is a whole nother way that we could another rabbit hole we could get down in terms of its significance and potential harms associated with our young people. But finding ways that they can adaptively socialize and safely do so is really important, because remember, no matter your kid's age, a massive part of their development is learning how to interact with the world, both their peers, with adults, with the environment. And that's changed, but it ought not just delete that part of their development. And so I think that's the thing to be mindful of, because in some ways we say, okay, well, we check the box, they're getting school in this different way. But over time, you can see that residual of social isolation. It has a lot of effects on kids that may be surprising to your otherwise resilient kids. They may become more anxious in social situations. So we see a lot of that, and just recognizing is, again, it's one of those where vulnerabilities rise. We recognize we can't replace with the previous structure for the time being necessarily, but within some modifications, recognize the need for routine and the need for socializing, and finding reasonable ways to go about doing that.
And a big thing for kids too is movement. They have got to expend energy. Look, we're used to coming into an office in the morning, sitting down, doing our work. Maybe we walk around a little. They change classes, they run around, they get free time. We've got to let our kids move. And so one of the things for coping with what's going on, the reentry aspect, whatever it may be, is, as Kevin's saying, we've got to have a routine for ourselves and our kids that we can engage with, that sort of sets the day up. And there are many things you could do with your kids, whether it's mindfulness or some kind of activity and game. Exercising and moving and doing that is so important. And then nighttime routines are important too. And this is especially where, set up a time where everybody puts their cell phones and their screens in a basket, and it's just for family around dinner time and such. And set up what's so important for individuals that we have worked with who have anxiety and depressive disorders. A lot of times what we find is they have a hard time just learning how to turn off and self-soothe. Find different ways of teaching your kids to do some self-soothing, and also for yourself. Is it taking a hot bath? Is it aromas that, of baking cookies, whatever it would be? Is it reading? What are the things that are soothing? These are the things to put into place in your home. These are great grandparents with the great grandkids. A thing I want to say for a lot of us, 28% of caregivers are sandwiched between the kids and the parents. And something, if we're going to take anything out of this slide, it's that both children and older adults want their independence. When you think about your little 5-year-old who's stomping his or her feet before, heading out to school because you're telling them to wear something specific, and, your daughter wants to wear the tutu and your son wants to wear his football uniform, that's their way of wanting to be independent. So what do? You learn to show the red dress and the green dress because those are acceptable, and they pick one. That's giving them a little bit of independence. Know that kids, especially middle school age and high school kids, think they have more independence and agency than they actually do, as do your college students. It's the illusion of independence and control we want to let them have. So think within reason. And then when it comes to those who are, our older parents and such, it's important for them to have their independence. And, while right now it's a difficult time, think about what has been taken away from them with the ability to get out and see their friends and do things. We have to and see their grandkids and stuff. We have to figure out ways to make sure people can be safe, especially our family members who may be more compromised, but also to get and engage with others in ways that they can so that they feel good about it. And oftentimes partnering everyone to work together is a way in the house for things to get done and there to be more harmony in living in the home. So normalizing feelings, emphasize the values you all share together, and find ways for connecting is most important, I think. And then in your workplace, what's important? I don't know how much people are in their office. I'm in the office all the time here. When I go back to New York, I haven't been to the office since March. Kevin's in the office on and off. Finding someone at work to cope with reentry, if that's something that you're doing, is important, again, because you have to know what your needs. We have varying levels here in Modern Minds of folks who have different responsibilities at home and also different levels of concern about infection. And we've got to be respectful of that and help one another to be able to be comfortable at work and to multitask what our work commitments, our home commitments, and don't forget those leisure activities and such. This is critical for everyone. Kev, reality checks.
Yeah, so I mean, and this is, again, we're tolerating some uncertainty. How do we, what happens when you're accustomed to, as part of an interaction where you shake hands traditionally? how do you signal, wait, do I default where I'm wearing a mask even if I'm distanced? Does the other person expect that or not? You know, figuring out what your default will be. And obviously they're part of the bonding with people is recognizing the shared awkwardness of trying to do some of our social norms in a different world. Sometimes that breaks the ice even by itself, just the acknowledgement that this is weird, but at the same time, we still want to do the traditional things. Thinking about how to interact with the world around, like, should we be prepared, like hoarding food? How do we travel? Will travel return to the way that it was before or not? So there's a lot about that weirdness. I think there's probably some collective understanding is that we're going to land sort of like a pendulum swings in a wild direction, but it's still going to swing back in some way. But will it land back where it was before or somewhere in between? Probably the latter, and recognize the idea that that we're going to find some ways to adapt to this, which many people have. And we have to think about, well, we'll be refreshed when some of the normal things come back, but also some things will be different. And meanwhile, we do have the very real specter, particularly for those who have medical vulnerabilities, is will I get sick? Will I be somebody that transmit illness to somebody else in my family who may be more vulnerable than I am? And how do I manage that while also trying to balance those social norms? So they're the things that we worry about, but it kind of comes back to the idea is that we have to confront these things, but also have some flexibility for the unknown, and also know that we're imperfect, and we're making our best decisions in an uncertain time.
And of course, the holidays are almost upon us, and so that's going to heighten some of the anxiety. I wanted to call folks' attention to an app that is fantastic called Mind Shift. You can find it online. It comes from actually up above the northern border of Canada. It's from Anxiety Canada, an organization. It's fantastic with giving you ways and walking you through calming techniques, and various ways of checking your thinking and such. It's wonderful. And also, if you just go to anxietycanada.com, they have excellent tips, especially for parents, on how to help manage any kind of stressors in your life. This is sort of from my crew up in New York, what they put together as we were working with the first responders and our healthcare professionals through the pandemic. To grow your resilience, to sum up the things that Kevin and I have been talking about, self-care is so critical, living your values and connecting with others, reflecting on where you are, what may be different, and how to manage, having hope, practicing things like mindfulness and being flexible in your thought. A big thing we didn't say a lot about, but it has to be there, is being generous with yourselves, your kids, those around you, and, get forgiving when things are going wrong and various things. So we have to be realistic with what we can expect from one another right now. And a big thing is hope. Things are going to change. They're going to get better all the way around, but it may take time. But all these struggles are going to be transient. And a big thing is being grateful. And I'll be home to my husband tomorrow, and then our little granddaughter. Grateful for the people in our lives. Kev?
And I only have part of my family here. This is my wife, my older daughter, who's a freshman at Clemson, and one of our 3 dogs. So my younger daughter, who just started high school this year. We have 2 other dogs that are a bit older, didn't make the trip up to move Megan into Clemson. But this is a reminder, of what is important to me in my world. Again, feeling guilty that I didn't get a picture of everybody together, but that's also a reminder that in unusual times, we aren't doing the usual things sometimes of getting the full family together for a picture. So like, setting up this PowerPoint deck reminded me when Anne-Marie was like, hey, get me a picture of your family. Dang it, like my younger daughter just started high school, older daughter started college, all these developmental things are happening. So while we're in this sort of weird time vortex of COVID where time stands still but moves too fast, real things are happening, and trying to be mindful of those moments and be appreciative of those milestones that are happening with family. So being grateful for those things is a good shift when we feel overburdened, overstressed, and recognizing the valuable things that we have right before us. And
we just want to, tell you we appreciate being here today. We're located in Calhoun Street, in the TD Bank building, taking referrals if you want to send folks to us, to our team. And again, thank you. And we'll take, if there are questions, we can answer them. I'll
Yes,
stop
thank you
sharing
both
this.
very much. I will see if anyone puts any questions in the chat and let you know.
Great, thank you.
And by the way, it's not a beer, it's green tea. All the different webinars I'm doing, people are commenting that, boy, you drink early. It's like, no, it is green tea. All right, thank you all.
Well, no questions have been asked, so thank you both very much again. We really appreciate it.
Okay, thank
Great.
you so much. We appreciate the opportunity.
Bye-bye.
And that concludes the CLE for the day. Thank you all very much for joining us. Have a good rest of the day.